पेमेंट के बारे में,
ये पेमेंट के बारे में है
जी।
in this case what happened
इस
was
लॉट
earlier-
इस ऑर्डर का एक पैराग्राफ पढ़ के मैं सुना देता हूँ, पेज 3 वाला,
प्लीज पढ़िए।
पेज 3 का
हाँ।
लास्ट बटन में थोड़ा सा नहीं। Therefore, this act of respondents,
जस्ट अ मिनट, पेज 3 पे पढ़ रहे हैं ना?
हाँ पेज 3 इस ऑर्डर का,
ये द ऑफर ऑफ 5% उसमें कहीं?
हाँ हाँ ये इसका लास्ट।
Therefore this act of, yes.
Therefore, this act of respondents become unsustainable. Either they are entitled to ignore the entire offer made by the petitioner, or they are entitled to accept the offer completely. They cannot accept half of the offer made by the petitioner while rejecting the other half. Therefore, the feature of rupees 50,000 EMD offered by petitioner in our considered opinion becomes unsustainable, since that is the prayer to that extent. Consequently, the petition is allowed. Therefore, the forfeiture EMD by respondent so and so to the extent of forfeiture satisfied. तो it has been held कि ये जो risk and cost का जो इनने second tender किया था,
जी।
अब सर इसके बाद इनके रिटर्न का एनेक्शर R5 देख लें लॉर्डशिप, पेज रिटर्न के रिटर्न का पेज 16 R5। यही ग्राउंड पे इन्होंने बोला था कि हम इसलिए पेमेंट नहीं दे रहे।
R5 में क्या लिखा है?
R5 इसी पिटीशन में जो डिस्पोज ऑफ हुई है, इसका इंटरिम ऑर्डर था लॉर्डशिप। ये The respondents are restrained from insisting the petitioner to deposit rupees 76,000 pursuant to the letter dated 76 lakhs pursuant to the letter dated itna until further deposit of the said amount shall be subject to result of this petition.
जी।
अब यही अमाउंट हमारा नहीं दे रहे हैं ये, और इनका ये कहना रिटर्न में कि उसमें हम विकेट हो जाएगा तो हम इनका अमाउंट दे देंगे, इतना सा इनका रिटर्न है। अब रिटर्न थोड़ा सा देख लें लॉर्डशिप,
बताइए।
रिटर्न ही यही है इनका।
जी पढ़िए।
At para 4 lordship written ka,
प्लीज पैरा पढ़िए।
the answering respondent humbly submit that a petition is so and so has filed WP number so and so before this honorable court against annexure R3 30-5-6 stating that risk and cost of petition is illegal and not binding on the petitioner, as the petition did not agree to the self-imposed condition made by respondent. The honorable high court, by order dated 5/10/17 granted the state order restraining the respondent from insisting the petitioner to deposit an amount of rupees so and so until further order. The said stay granted by honorable is still in force. The copy of stay order filed so and so that as per the terms and condition of NIT, the letter of acceptance petition has refused to perform the contract. As a result, respondents railway department caused loss and damage of rupees itna which has been kept in deposit in account to succeed in present rate petition. अब क्या हुआ लॉर्डशिप, उनने हमारा जो प्रेजेंट का काम है, जो प्रेजेंट पिटीशन है, इसका काम सेटिस्फैक्टरी हमने कर दिया, उसमें कोई आपत्ति नहीं। उसका ये पैसा, उसमें उसका रिस्क एंड कॉस्ट जो कैलकुलेट किया था 76 लाख, वो हमारे फाइनल बिल के समय ने रोक लिया। अब ये पिटीशन डिसाइड होगा हमारे फेवर में, ये होल्ड हो गया। कोर्ट ने बोला कि हमारा एक्ट, उनका एक्ट जो था अनसस्टेनेबल इन लॉ था। उसी के बेसिस पे इन्होंने रिस्क एंड कॉस्ट पे सेकंड टेंडर किया था। अब सेकंड टेंडर का हमने एक एक चीज जो है कंप्लीट कर दिया, इसका कोई मतलब खंडन नहीं है, इसका सेटिस्फैक्शन।
क्या बचता है?
पैरा 5 of our return में kindly भी
हाँ वही तो देख रहे हैं।
अब in light of that it may be disposed of that now the authority may take the decision.
श्री गिरीश श्रीवास्तव, गिरीश कुमार श्रीवास्तव, लर्नेड काउंसिल फॉर द पिटीशन।
गिरीश श्रीवास्तव लिखा,
गिरीश कुमार लिखा हुआ है।
अच्छा,
कॉस्ट में
ठीक ठीक।
आप कुमार से अब
नहीं लिखता नहीं, नॉर्मली लिखता नहीं मैं, इसलिए
नहीं ऐसा ट्रांजिशन होता है ना, राजकुमार से राजा बन जाते तो फिर कुमार हट जाता है। गिरीश श्रीवास्तव लिख दीजिएगा भाई, श्री गिरीश श्रीवास्तव, लर्नेड काउंसिल फॉर द पिटीशन। Shri Pushpendra Yadav, Learned Deputy Solicitor General for the Union of India. Next pair. Controversy in this case is that respondents are withholding certain outstanding payment of the petitioner under the contract performed by the petitioner to the satisfaction of the respondents. Full stop. Shri Srivastava submits that in WP 4221 of 2007 between Narayan Singh Bundela and others versus Union of India, Ministry of Railways and others, wide order dated 16th February 2022, Honorable Division Bench of this court has held that respondents were not justified in withholding the earnest money deposit of the petitioner by way of forfeiture and has set aside the and has quashed the order of forfeiture and has set aside the order of forfeiture and directed them to refund the amount of EMD along with 6% interest per annum from 30/5/2006. Next pair. It is pointed out that in the present petition, while filing their reply, respondents have taken a specific plea in para 5, which reads as under: colon dash within inverted commas 5 dot that comma as per terms of condition of previous NIT and letter of acceptance, petitioner has refused to perform the contract. As a result, respondents railway department caused loss and damage. ये तो आपका एडमिशन है that you caused loss and damage. इसकी अंग्रेजी तो पढ़ी है इसकी, आपके रिटर्न की. As a result, respondents railway department caused आएगा कि sustained आएगा? भारत सरकार की भी स्थिति ऐसी ही है, उनकी भी अंग्रेजी कमजोर है. क्या लिखा? Caused loss and damage of rupees 760,600,7.14, which has been kept in deposit account in order to succeed in the present WP. Full stop. Respondent नहीं, full stop नहीं. Respondent can छोटा ही छोटा ये देख के पेज 4 पे से पूरा exactly quote करना inverted comma. Respondent can recover the said amount, otherwise it would be difficult to recover the said amount. Full stop. Next para बनाते हुए. Further action for releasing the amount which is kept and deposit will be taken after stay is vacated and according to the direction of the Honorable Court. Full stop, inverted commas closed. It is submitted that since stay has been vacated in WP 4221 of 2007, directions have been issued to refund the EMD deposit, and admittedly petitioner has performed his contract to the satisfaction of the employer. That amount which has been kept is liable to be refunded.
As our interest जो भी
सब आएगा भी. Full stop. Shri Yadav submits that fairly submits that orders can be passed in terms of para 5 of the return, where there is admission for releasing the amount after vacation of stay. Full stop. Next para. Taking these facts into consideration, respondents are directed to refund the amount as mentioned in para 5 of their return, along with interest strictly in accordance with the terms and conditions of the contract within period of 30 days of communication of this order. In above terms, petition is disposed of with the consent of both the parties.
So 60 days.
60 days का दी.
Serial number 19. Serial number 19. To Pinay Gupta. Lordship, these are two linked matters. My lord, petitioner has died and we've moved an application under Order 22, Rule 10A. First, to intimate them also in one of the case and also for praying for substitution of the legal representatives in
क्या
another.
मैटर क्या है?
My lord, we have prayed for retiral dues, release of the retiral dues of the petitioner, my lord.
ओके, आप किसके लिए हैं?
Sir, in one of the matter I am from the petitioner and another matter I am from the respondent, Your
So
Lordship.
you are appearing for मध्य प्रदेश राज्य सहकारी दुग्ध
Yes.
महासंघ।
Yes, sir.
इनकी 2210A की एप्लीकेशन पे क्यों नहीं लीगल ईयर सब्स्टिट्यूट करते हैं आप?
Sir, I have,
Wait,
sir, I have already filed the application for substituting legal heirs, Your Lordship.
अच्छा, heard on आइए 133, आपका शुभ नाम बताइएगा।
Adarsh Jain.
आदर्श
Jain.
जैन for the petitioner. Heard on आइए 1331 of 23, an application for substitution of legal heirs. Same is allowed. देख लेना ये 1331 है कि 3719 है, जो भी हो उसको लिख के same is allowed. Let necessary correction be carried out during the course of the day. List इसी दूसरे वाले में 1334 allow कर दीजिएगा और list for final hearing as per his turn and seniority in part B of the clause list. Petition is already admitted. चलिए
Lordship, if this can be, if any fixed date may be given because.
आएगा फाइनल हियरिंग में आ जाएगा। 22 तक के केस चल रहे हैं फाइनल हियरिंग में।
Lordship.
Lordship.
Period number 20, Sri Ravi Shankar Patel.
My lords, I've moved an application for order 22 rule 3 for substitution of LRs of petitioner number 1.
देखिएगा heard on IA
5550
550 of 23 for substitution of legal heirs of the petitioner number 1. Same is allowed. Let necessary correction be carried out within 7 working days. List for final hearing as per his turn and seniority in part B of the clause list.
Ronit Singh.
Period number 21, Sri Prasad Gupta.
In this matter, Lords, may kindly see the last order sheet for a moment, Lords.
Yes.
Well, this order has not been complied with, Lord, till date.
Here none for the petitioner. There is non-compliance of the earlier order. Dated 15/6/22. Amendment कब allow हुआ है?
आप 15 से को लाओ तो फिर आपने extension of time
15/6/22. No application for extension of time is filed till date. Nobody is appearing for the petitioner. It appears that petitioner has lost interest in pursuing the remedy. Petition is dismissed for want of prosecution. So best. इनका नाम डाल दीजिएगा। शोभादित्य फॉर रिस्पोंडेंट नंबर 1 और स्टेट के लिए इनका नाम डाल दीजिएगा पीयूष जैन।
Period number 22,
My lord, इसमें आइए as extension of time limit किया था for amendment of sole petition.
कब अलाउ हुआ था अमेंडमेंट?
5/1 फाइल किया था,
है
5 जनवरी को फाइल किया था सर।
क्या एक्सटेंशन एप्लीकेशन?
जी
अमेंडमेंट कब अलाउ हुआ था?
अमेंडमेंट सर लास्ट हियरिंग में सेम डे कोर्ट में ही हो गया था, लेकिन कोर्ट में जो अमेंडमेंट किया वो प्रॉपर नहीं होना से
16/12
रजिस्ट्रार कोर्ट ने कहा कि इसको प्रॉपर अमेंडमेंट करिएगा।
Heard on IA 161 of 23, an application for extension of time to carry out the amendment allowed on the last date. Application as not opposed by Shri Aditya Adhikari, learned senior advocate, assisted by Shri
Ijaz Siddiqui.
Azaz
Siddiqui.
Siddiqui, is allowed. Let necessary correction be positively carried out within 7 days. List thereafter.
Unless
He carried out peremptorily कर देना, positively नहीं तो peremptorily.
Serial number 23. Ikea Saket Malik.
My lords, in this case, I am praying for a week's time to move appropriate application for dispensing of the service upon respondent, upon the unserved and respondents.
Saket Malik is for time to move an appropriate application. Full stop. Petition is admitted for final hearing. List for final hearing in part B of the cause list as per its turn and seniority.
My lords, IA may kindly be continued.
Huh?
IA may kindly be
कौन
continued.
सा IR है?
My lords, it was granted on 2012-2014 status.
उसके बाद तो कंटिन्यू हुआ नहीं, उसके बाद तो कई सारी ऑर्डर शीट देख ली.
My lord.
2/4/19 यू प्रेड फॉर टाइम, कंटिन्यू नहीं हुआ. 9/4/19 कंटिन्यू नहीं हुआ. 29/7/19 कंटिन्यू नहीं हुआ. 5/8/19 आप आए नहीं. 26/8/22 सीनियर एडवोकेट अपीयर्ड, लेकिन देयर इज नो प्रेयर फॉर कंटिन्यूएशन ऑफ IR. देखिएगा, रिक्वेस्ट ऑफ श्री साकेत मलिक टू कंटिन्यू द IR इज नॉट जस्ट एंड करेक्ट. It is evident that since 2/4/2019, this case was listed on several occasions and IR was never continued. Therefore, this request to continue IR is hereby rejected.
Serial number 24. Bhupen Kumar Mishra. Pawar.
Respondent number 2.
My lord, WP number 1409 of 2015, इसमें withdrawal of petition है.
देखिएगा, heard on
My
IA.
lord, इसका ऑब्जेक्शन है. इतने सालों हमको कोर्ट में ड्रैग किया, हम रिस्पॉन्डेंट
अरे
नंबर
भाई, he is the master of his this thing. He can, देखिएगा, आपका ऑब्जेक्शन overruled. Heard on IA 16517 of 2022, an application for withdrawal of the writ petition. Doshri Nilesh Kotecha for respondent number 2 has serious objection to said IA, but petitioner being master of his pleadings is entitled to withdraw his writ petition. Accordingly, writ petition is dismissed as withdrawn. IA is allowed, dismissed as withdrawn. चलिए, अब अगले केस में बताइए.
My lord, in this case, petitioner are tenant, my lord, and respondent number 2 owner of the disputed non-residential house.
जी.
Lordship, respondent number 2 earlier filed suit for eviction and vacant possession against the petitioner.
जी.
Civil suit still is pending, and in 2007.
फिर आप आज ये पिटीशन किस बात के लिए लेकर
फिर
आए?
माय लॉर्ड, इसमें रिस्पोंडेंट नंबर 2 ने 2 साल बाद 2009 में एक इन्होंने जन शिकायत में एप्लीकेशन देते हैं, इस मकान को जर्जेस घोषित करके हमको
उससे आप-
परमिशन दिया जाए
हाँ.
डिमोलिशन के लिए. माय लॉर्ड, कंडीशन एनेक्जेट P1 इंटायर
अरे इसको सिविल सूट को डिसाइड करने के लिए बोलते हैं 6 महीने में.
माय लॉर्ड,
अब इससे ज्यादा इसमें क्या होगा आज 10 साल बाद? ठीक है,
जी मैम.
लिखिए.
सिविल सूट में स्टे है,
वो सब स्टे वेकेट करके 10 महीने में डिसाइड करें. श्री
फाइनली स्टेज पे है सिविल
भूपेंद्र कुमार मिश्रा
यस माय
फॉर द पिटिशनर. श्री
Rahul Patil.
Rahul Pathak for
Respondent number 1 municipal.
correspondent number 1 municipal corporation. Shri Nilesh Kotecha for respondent number 2 landlord. It is agreed between the parties that at this stage, trial court can be directed to expeditiously decide the civil suit on its own merits rather than involving in technicalities. This prayer is not opposed. Accordingly, this petition is disposed of with a direction to the trial judge, namely, क्या नाम है?
उसमें वैकेटिंग स्टे की एप्लीकेशन में है
नाम
सेकंड सिविल जज क्लास 2
Second Civil Judge Junior Division, Patni, to decide the pending suit expeditiously and if possible within a period of 6 months without affording any 6 months of communication of this order without affording any undue adjournment to any of the parties. Full stop. The stay granted earlier shall stand. In above term, petition is disposed of as withdrawn. Stay granted earlier shall stand vacated.
Serial number 25. Kumar Gupta.
It's a service matter, Your Lordship, against the award of the level court, by which the petitioners were directed to reinstate the respondent. Without the
सर्विस मैटर नहीं है ये, 227 की है, 227 का हमें जुरिस्डिक्शन है
जी,
हाँ सुनाइए
uh,
किस ग्राउंड पर आए हैं आप?
today it is listed on document taken on record.
वो तो ठीक है,
It may be listed on next Wednesday, I will argue.
नहीं 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 ये सब नहीं.
Actually, I have not gone through on merits here.
You should have gone through the merits. कितने केस मिलते हैं प्रति सरकारी वकील? 10 केस भी नहीं मिलते आप लोगों
जी
को.
नहीं
10
एक्चुअली
केस भी आप अगर पढ़ के नहीं आ सकते.
नहीं नहीं
आपके
इसमें
इतनी लंबी फौज है,
जी जी
10-15 तो पैनल लॉयर रहते हैं,
नहीं नहीं मैं पढ़
8-10
लेता
गवर्नमेंट एडवोकेट रहते हैं.
नहीं मैं पढ़ लेता इनका रिप्लाई भी रिकॉर्ड पे नहीं था और ये जो एप्लीकेशन फॉर टेकिंग डॉक्यूमेंट ऑन रिकॉर्ड है ये भी हमारी फाइल में नहीं थी तो मैं उसे फाइनली नहीं होगा.
अच्छा आपके इम्प्रेशन से कुछ नहीं होता है?
इसको नेक्स्ट वेडनेसडे कर दे मैं कर दूंगा इसको मेरिट पे प्रिपेयर करके कर दूंगा.
श्री
सर एक
अमित
WP
शर्मा
हमारी भी सर
वो नंबर दे दीजिए, लिख के दे दीजिए.
यस मैम.
Amit Sharma, learned counsel for the petitioner is not prepared, learned government advocate and counsel for the petitioner is not prepared with the matter. On his request, reluctantly case is adjourned. List along with इनका नंबर जो देंगे वो लिख लीजिएगा. चलिए
चलो
नेक्स्ट केस.
पहले हो जाए.
Serial number 26.
Lordship, it's an injury case wherein 2 trucks and 1 tanker were involved in the accident. The appellant, being driver of the tanker, was also held liable for contributory negligence and 1/3 has been deducted out of the total award. The total award was calculated to 3,46,920. 1/3 deducted, thereby round off 2,31,000 is been the total award awarded by the tribunal. About 40% PDC was granted by the doctor, who has in his evidence also has stated that he, being the heavy driver vehicle, would not be in a position to drive the
क्या चोट है?
vehicle. Malot,
पढ़ेगा.
short fracture of right femur bone and right patella bone and multi-fracture in right foot. 40% PDC has been constituted to
ठीक है, उसको
20%
माना है.
20%.
ठीक है, बताइए कहाँ है डॉक्टर की एविडेंस की आगे ट्रक नहीं चला पाएगा?
मतलब पैराग्राफ 19 में काइंडली भी
पैराग्राफ 19 पढ़िएगा.
छोटे व्हीकल चला सकता है ऐसा बोलता है. चिकित्सक साक्षी विपिन दुबे ने प्रतिपरीक्षण में यद्यपि स्वीकार किया है कि उसके द्वारा मरीज का प्राथमिक उपचार व प्राथमिक ऑपरेशन MLC, किंतु मात्र इस आधार पर उक्त चिकित्सक साक्षी की अभिसाक्ष्य अस्वीकार योग्य नहीं है. आहत के बिरला अस्पताल सतना में सो तक भर्ती रहा. भर्ती रहकर ऑपरेशन उपचार की स्थिति प्रदर्श P0 डिस्चार्ज कार्ड सहित सुसंगत अवधि के उपचार से स्पष्ट हुई है. उक्त चिकित्सक साक्षी ने यह भी स्पष्ट किया है कि आहत को जिस तरह की स्थायी अपंगता है उसमें उसकी ड्राइवरी का काम करने में उसे कठिनाई होगी.
कठिनाई होगी इज डिफरेंट एंड नहीं कर सकता. देयर इज अ डिफरेंस.
यस मैम.
डेट ऑफ एक्सीडेंट क्या है?
मतलब डेट ऑफ
1/12/2012.
मतलब
1/12/2011.
मतलब
कितनी वेज ली है? चलिए
मतलब 5,000 रुपीज इनकम हैज बीन असेस्ड.
हाँ तो उसको देख लेते हैं उसमें कितनी बढ़ा सकते हैं.
इफ my lord appreciate the skilled labor.
हाँ ठीक है, स्किल्ड ही मानेंगे इसको.
5,225.
2011 कितनी
और
मानी है इन्होंने?
इन्होंने 5,000 रुपए मानी है.
हाँ तो 4,825 रुपए है स्किल्ड की.
सर 5,225 है सर.
एक्सीडेंट की तारीख को, एक्सीडेंट की तारीख है 1/12/2011. 1/12/2011.
1/11/12 है.
हाँ 1/11/12 ही पढ़ रहे हैं
सर.
1/11/12 को 4,825 है.
सर ये
13 का पढ़ रहे हैं आप.
1/11/12 को है सर 5,050 सर.
नहीं
स्किल्ड की,
स्किल्ड की पढ़ रहे हैं हम.
सर
हमारे पास जो चार्ट है ये
सर,
ये 1 सेकंड रुकिएगा. हाँ 1 सेकंड, क्या डेट है? एक्सीडेंट की डेट है 1/12/11. 31/3/12 तक 4,825 है. आप जो 5,050 बोल रहे हैं वो 1/4/12 से 30/9/12 तक है।
सर इश्यूज में देखिए सर 1/11/12 लिखा है सर।
हाँ तो 1/11/12 ही तो बता रहे हैं। 1/11/12 कहाँ लिखा है? ऊपर पढ़िए, पैराग्राफ 1 पढ़िए।
पैराग्राफ 1
आवेदक
हाँ,
ने धारा
इन्होंने
के आवेदन से
1/12/11 लिखा है
1/12/11 लिखा, फिर
और
और पढ़ा जाएगा ना भाई।
सर नहीं सर, लेकिन पैरा 10 में भी देखे
पैरा
सर
10 में गलत लिख रहे हैं।
1/11/12 इश्यूज
या
में
तो
भी एक
FIR दिखा दीजिए, FIR से देख लेते हैं।
सर। हाँ वो कंफ्यूजन हो रहा है।
FIR पढ़िए, FIR किस तारीख की है?
घटना बिना नहीं है। ये जवाब दावा आपका अनदर सर, ये जवाब दावे में भी 1/11/12 ही दिख रहा है जो इनका है।
नहीं जवाब दवा नहीं, FIR पढ़िए,
FIR की कॉपी में
रिकॉर्ड कहाँ है इस केस का? FIR पढ़िए, FIR होगी आपके पास में।
FIR नहीं है।
FIR में क्या डेट है? चलिए इधर दीजिए, आपकी फाइल दीजिए, 2 मिनट में बताते हैं आपको।
मल्टीप्लायर 18 का लगा है सर, 17 का लगेगा इसमें।
तो इसको रहने दीजिए, आपकी अपील है, उनकी अपील छोड़ना है।
नहीं बट फॉर फेयर इन ऑल फेयरनेस। पाँच हजार 25 हो गई। एक 10/12 एक 11
हाँ ये डेट 12 ही है
सर।
ये इंश्योरेंस पॉलिसी से मालूम पड़ रहा है, थोड़ा सा ध्यान तो दिया करो। इंश्योरेंस पॉलिसी में प्रीमियम कलेक्ट किया गया है 20/1/2012 को
सर,
और इंश्योरेंस की वैलिडिटी है फ्रॉम 23/1/12 टू मिडनाइट ऑफ 22/1/13। 12 की डेट है, उतना अमाउंट बढ़ जाएगा बस, और क्या।
Lordship, future growth of 40%, as well as my lord, if my lord functional disability is to be assessed at least 30%, my lord.
वो सब नहीं, फ्यूचर ग्रोथ ऑफ 20% एंड इनकम
Future growth 40%, and multiplier
फ्यूचर
of
40। हाँ
multiplier 17 का लगेगा, 18 का लगाएगा हमें।
प्रोस्पेक्ट 40%, इनकम 5250 मल्टीप्लाई 17 instead of
Lordship, or 1/3 would be deducted towards contributory negligence.
instead of 18, 1/3 deduction towards।
My lord, other heads may also be kindly be appreciated, my lord.
दे दिया, काफी दे दिया।
My lord, only 50,000 has been assessed, my lord.
Contribute।
My lord, may kindly see.
ठीक है, देख लेंगे, चलिए।
Grateful.
Item number 27 will be taken up after lunch, proceeding before the SDO pending before the state from the.
भाई सब लंच के बाद देखेंगे ना, फाइनल हियरिंग का डे है आज।
I'm appealing, although, my lord, in 27, my lord, there is a civil suit filed by them. So nothing remains in this matter, my lord, for adjudication so far as my contention is now, because the civil court ought to have adjudicated the issues.
So you are withdrawing your petition?
My lord, my lord, I am only seeking direction. Whatever the outcome of civil court, that would be binding because mutation proceedings were under trial.
Shri Himanshu Mishra prays for withdrawal of this petition. as civil suit is pending and all the rights and liabilities of the parties will be subject to the outcome of the said civil suit.
Yes.
The Himanshu Srivastava for respondent number 3 has no objection to this prayer. Accordingly, petition is dismissed as withdrawn.
My lord, and not disposed of maybe.
Disposed of as withdrawn.
फाइनल हियरिंग लो मेरा 28 है क्यों भैया हाँ
here. My lord, please, senior is also adjusted, my lord. एक लेटर बस देख लें उसका, my lord, उसमें actually impugned है, please, my lord. मैं
वो
दौड़ते
फाइल
हुए
बनवा
से,
के दिखा दीजिएगा, फ्लैग करके दे दीजिएगा, देख लेंगे उसको।
my lord.
इनका नाम डाल दीजिएगा।
May it please, your lordship. My lord, your lordship, this is a petition. My lord, this is a petition wherein the husband of the petitioner has died in custody of the police, my lord.
Police.
Yes, your lordship. This is a matter of custodial death, sir.
Yes.
What my humble submission before your lordship is that, sir. What I state, your lordship, that the husband of the petitioner, who is the deceased, namely Bhagirath, he was taken in custody on 6/7/2000, my lord.
Bhagirath.
6/7/2000, my lord. And he has died on 14/7/2000, my lord.
14/7/2000.
Lordship.
जी.
Now, your lordship, the respondents have not placed on record what I have, any particular intimation that my husband was arrested or any particular arrest memo that he has been arrested. What they state in the reply, your lordship, is that he was arrested on 14/7 right in the morning, sir. Matlab between the night of 13 and 14, he was arrested, now. And thereafter he has died on 14/7 itself, my lord. What I state is that your lordship may kindly see the post-mortem reports, my lord. The post-mortem report, your lordship.
Annexure.
Sir, seeing the status of the file, your lordship, I have placed that on some IA, your lordship. If your lordship
You should
wants,
be aware which IA number.
sir, the status of the file is that,
you reconstruct your file.
your lordship. If your
Okay,
lordship,
what's your good name?
sir,
Shri Ishan Dutt submits that his file is not well organized to assist the court. Full stop. After opening arguments, he submits that he needs time to reorganize his file. So to assist court properly. On his request, list this case next week.
highly grateful. Highly grateful.
Number 23.
साफ करो।
किताबें निकल गई,
बताइए।
किताबें निकल गई, ये साहब को दे दूंगी।
But the document was not properly stamped, my lord. That's why it was sent to the collector stamp, my lord. And by annexure P3, my lord, the light of section 47, A, my lord. The Stamp Act, my lord. That the finding has been recorded in in page 17, my lord. How the assessment has been carried out, my lord. The प्रतिवेदन was called from the डिप्टी रजिस्ट्रार, my lord. उप पंजीयक ने अपने प्रतिवेदन की कंडिका 10 में बताया कि संदर्भित दस्तावेज की संपत्ति राइट टाउन जबलपुर प्लॉट नंबर 28 रकबा 0.903 एकड़ अर्थात 29,656 वर्ग फुट, जिसमें 4 मंजिला भवन 31,200 वर्ग फुट सन 1970 का बना अशोका होटल के नाम से प्रसिद्ध है। चूंकि उपरोक्त विवरण के आधार पर मूल्यांकन संभव नहीं था, अतः क्रेता श्री नरेश ग्रोवर से फ्लोर साइज नक्शा प्रस्तुत करने को कहा। नक्शा मिलने के बाद उसका अवलोकन किया गया। नक्शा में तल मंजिल 8,500 वर्ग फुट, प्रथम मंजिल 5,675 वर्ग फुट, द्वितीय मंजिल 5,675 वर्ग फुट, तृतीय मंजिल 5,675 वर्ग फुट एवं चतुर्थ मंजिल 5,675 वर्ग फुट नक्शे को लेकर विस्तृत स्थल निरीक्षण किया। स्टेडियम के पास कार्नर में स्थित मुख्य द्वार साइड रोड की तरफ रोड की ओर एक आपात द्वार भवन पुराना होने के कारण मरम्मत का कार्य जारी। बाहर से स्ट्रक्चर पूर्वक कोई परिवर्तन नहीं नक्शा अनुसार पाया, परंतु 20 × 60 इक्वल टू 1200 स्क्वायर फुट का मेजनाइन तल मंजिल पर एवं चतुर्थ मंजिल के ऊपर 25x10 इक्वल टू 250 वर्ग फुट का ओवरहेड टैंक भी पाया। छत की सीलिंग की लकड़ियां दीमक के कारण खराब, काफी मरम्मत की आवश्यकता, गत 6 माह के बंद होने के कारण कोई व्यवसाय नहीं हो रहा। स्थल निरीक्षण नक्शा व गाइडलाइन में दिए गए निर्देशों के अनुरूप बाजार मूल्य का मूल्यांकन निम्नानुसार किया गया। सो दैट असेसमेंट हैज बीन मेड ऑन द बेसिस ऑफ द मार्केट वैल्यू, माय लॉर्ड। सो दिस इज द market value, my lord. This is the assessment has been carried out by the collector, my lord, collector of stamp, my lord. और उसके बाद इन्होंने कहा अतः अनावेदक के अधिवक्ता द्वारा प्रस्तुत जवाब साक्ष्य, तो रिप्लाई what they have submitted, my lord, that has been taken into consideration. The evidence what they have produced, that has also been taken into consideration. Then the उप पंजीयक द्वारा स्थल निरीक्षण करने के बाद दिया गया मूल्यांकन जो कि कंडिका 10 में बताया गया है, सभी तथ्यों का अवलोकन किया गया, जिसमें पाया गया कि संपत्ति का कुछ मार्ग मुख्य मार्ग पर है तथा कुछ भाग उपमार्ग पर है। संपत्ति का निर्माण 1970 के आसपास का है। अतः केंद्रीय मूल्यांकन बोर्ड द्वारा दिए गए निर्देशानुसार, सो दिस इज द केंद्रीय मूल्यांकन बोर्ड, माय लॉर्ड, एज पर सेक्शन 47 के, माय लॉर्ड। हाँ, निर्देशानुसार उप पंजीयक द्वारा निर्माण में छूट देते हुए मूल्यांकन किया गया है। पूर्व में संपत्ति का उपयोग अर्ध व्यावसायिक रहा है, वर्तमान में भी संपत्ति के आसपास का क्षेत्र व्यावसायिक अर्ध व्यावसायिक है। अतः पंजीयक द्वारा उपरोक्त सभी तथ्यों को ध्यान में रखते हुए संपत्ति का मूल्यांकन कर बाजार मूल्य कितने होना बताया। अतः उप पंजीयक द्वारा बताया गया मूल्य उचित है। अतः उप पंजीयक के मूल्यांकन से सहमत होते हुए संपत्ति का बाजार मूल्य 4,53,13,000 अवधारित करता हूं तथा कमी मुद्रांक शुल्क 12,59,845 जमा करने हेतु पक्षकार को आदेशित करता हूं। देन दिस ऑर्डर हैज बीन affirmed by the divisional commissioner, my lord, and the divisional commissioner has recorded the finding in page 20, my lord. जी। उपरोक्त दोनों बिंदुओं पर कलेक्टर ऑफ what they have pleaded in the appeal, my lord, that point has been taken into consideration. Then the finding has been recorded by the divisional commissioner, my lord. क्या? उप पंजीयक जबलपुर से प्रकरण प्राप्त होने पर जिला कलेक्टर ऑफ स्टाम्प द्वारा इसे दायर किया और सूचना पत्र अपीलार्थी गण को दिया। उन्हें सभी बिंदुओं पर सुना गया। अपीलार्थी गण की संपत्ति राइट टाउन स्टेडियम के निकट स्थित है, जिसकी यह कोने की संपत्ति है। इसके दोनों ओर सड़क है, एक और प्रमुख सड़क है और दूसरी ओर साइड रोड है। बिल्डिंग में साइड रोड तथा मुख्य मार्ग दोनों पर ही प्रवेश द्वार बने हुए हैं। यह निर्विवादित है कि यह व्यावसायिक संपत्ति है और मूल रूप से पूर्व में अशोक होटल के नाम से संचालित थी। अपीलार्थी द्वारा भी इसे परिवर्तित कर होटल के रूप में उपयोग किया जा रहा है, जो विशुद्ध रूप से व्यावसायिक कार्य है। सेकंड मालोट, कलेक्टर ऑफ स्टाम्प ने अनावेदक गण को सूचना देकर पूरा सुना और मौके का निरीक्षण भी किया। अपीलार्थी गण द्वारा कलेक्टर ऑफ स्टाम्प को तत्समय ही जो मूल्यांकन नियत किया गया था वह राशि इतने को जमा कर दी है। 30/3/2002 को जमा कर दी। कलेक्टर ऑफ स्टाम्प ने अपने प्रतिवेदन में बताया कि पक्षकार को नहीं किया गया था और पक्षकार द्वारा उक्त राशि जमा करने से पूर्व या बाद में कोई आवेदन विरोध स्वरूप भी प्रस्तुत नहीं किया गया।
विदाउट अंडर प्रोटेस्ट।
जी, अतः उन्होंने विरोध की बात बाद का विचार होना बताया है। सो दैट इज द एप्लीकेशन दैट इट इज प्योरली आफ्टर थॉट, माय लॉर्ड। प्रकरण के समस्त तथ्यों को देखने के पश्चात मैं इसका निष्कर्ष पर पहुंचता हूं कि संपत्ति मालिक द्वारा मार्ग का सही उपयोग न करने से इस संपत्ति की कीमत कम नहीं हो जाती। होटल के दोनों ओर मार्ग बने हुए हैं और दोनों में ही प्रवेश द्वार हैं। मार्ग का उपयोग न करने बाबत भी किसी प्रकार का कोई बंधन अपीलार्थी पर नहीं है। आवश्यकता अनुसार वह कभी भी किसी भी मार्ग का उपयोग कर सकता है। जिला पंजीयक ने बताया कि बाजार मूल्य की दरें केंद्रीय मूल्यांकन बोर्ड मध्य प्रदेश भोपाल द्वारा अनुमोदित है और उसी अनुसार निर्धारण किया जाता है।
फिर क्या हुआ?
बोर्ड ऑफ रेवेन्यू, माय लॉर्ड, before the board of revenue, my lord, this is the finding from page 11, my lord.
Page 11, yes.
Page 11. Various revenue nirnay has been cited, my lord, before the board of revenue. Then the board of revenue has given a finding. उपरोक्त दी गई न्याय व्यवस्था से स्पष्ट है कि अपीलांट पर जो स्टाम्प एवं मुद्रांक शुल्क निर्धारित किया गया वह न्याय संगत न होकर नैसर्गिक न्याय सिद्धांतों के विपरीत है। अपीली न्यायालय विद्वान आयुक्त ने भी उनके द्वारा पारित आदेश स्थिर रखा है। मेरे मत में उपरोक्त दिए गए न्याय दृष्टांतों को दृष्टि में रखते हुए उपरोक्तानुसार पंजीयन एवं मुद्रांक शुल्क नहीं लगाया जा सकता है। यह भी उल्लेखनीय है कि सब रजिस्ट्रार एक तकनीकी अधिकारी नहीं है। उसे निर्माण का पूर्ण अनुभव न होने से वह संपत्ति का वास्तविक मूल्य
किस बेसिस पे फाइंडिंग आ रही है?
मैं बताता
हाँ,
हूँ।
बताओ।
मतलब अपने परमिट में जस्ट
नहीं, इनको पहले बता दें
जी।
उसके बाद का।
इसके लिए तकनीकी विशेषज्ञ, सब इंजीनियर, सिविल आदि का होना आवश्यक है। वे ही बारीकी से संपत्ति का मूल्यांकन कर सकते हैं, जिसके आधार पर किसी संपत्ति का मूल्यांकन कर उसका सही मूल्य निकाला जा सकता। सो माय लॉर्ड, व्हाट दे हैव प्लीडेड माय लॉर्ड कि उपपंजीयक ऐसा नहीं कर सकता है, दैट फाइंडिंग हैज बीन रिकॉर्डेड एंड दैट हैज बीन टेकन इनटू कंसीडरेशन बाय द बोर्ड ऑफ रेवेन्यू विदाउट एनी बेसिस। बाजार मूल्य के अवधारण हेतु तथा अवक्षण की को निर्धारित कर मूल्यांकन करने हेतु शासन को मूल्यांकन करने वाले तकनीकी अधिकारी नियुक्त करना चाहिए ताकि न्यायिक निराकरण में सुविधा हो। नगर निगम द्वारा सुभद्रा कुमारी चौहान मार्ग को वाणिज्यिक मार्ग घोषित नहीं किया है, अतः बिना उक्त घोषणा के एवं आधार के वाणिज्यिक क्षेत्र मानकर किया गया मूल्यांकन मेरे मत से विधि सम्मत नहीं है। अपीलांट की ओर से मूल्यांकन के संबंध में दिए गए प्रमाण जो रिकॉर्ड में उपलब्ध हैं पर अविश्वास करने का कोई आधार नहीं है, अतः मेरे मत से उक्त मूल्यांकन जो तकनीकी व्यक्ति द्वारा किया गया है के आधार पर मूल्यांकन कर उचित रूप से स्टाम्प ड्यूटी लगाया जाना पाता हूं। अब यहाँ पे इन्होंने ये फाइंडिंग कर दी, अतः मेरे मत से उक्त मूल्यांकन जो तकनीकी व्यक्ति द्वारा किया है के आधार पर मूल्यांकन कर उचित रूप से स्टाम्प ड्यूटी लगाया जाना पाता हूं। उपरोक्त विवेचना के आधार पर तथा न्याय दृष्टांतों के परिप्रेक्ष्य में यह अपील स्वीकार की जाती है तथा कलेक्टर ऑफ स्टाम्प जबलपुर का आदेश दिनांक इतने उसको सेट असाइड कर दिया। So my lord, the assessment has been made by the collector of stamp, my lord, absolutely as per the provision laid down under section 47A of the Stamp Act, my lord.
47A निकाल देंगे।
इसमें 47A में 1A है, my lord.
जी।
1A, where the market value as set forth in the instrument is not less than the minimum, then 2, my lord. On receipt of a reference under subsection 1, the collector shall, after giving the parties a reasonable opportunity of being heard and after holding an inquiry in such manner as may be prescribed, determine the market value of property which is the subject matter of such instrument and the duty as aforesaid. The difference, if any, in the amount of duty shall be payable by the person liable to pay the duty. So, my lord, the inquiry has been conducted, and as per the central report, central
valuation
team report, my lord. So, taking into consideration, my lord, that assessment has been made, my lord.
ठीक, ये आप बताइए।
My lord, the statement may kindly be noted, my lord, that the valuation has been done as per the report of the Central Valuation Committee. Now, my lord, my respectful submission, my lord, before adverting merits, my lord, on the merits, their contention, my lord, that the valuation has been done on the basis of the circle rates and the valuation committee, my lord, that has no legs to stand, my lord. My lord, there are four judgments, my lord, two of this honorable court and two of the honorable Supreme Court, wherein, my lord, the honorable courts have been pleased to categorically hold that the circle rates do not have any binding force and they are only for persuasive value, my lord. They're only to determine the prima facie value.
Okay.
My lord,
कौन से जजमेंट है वो?
my lord, I have given the list, my lord.
कौन से?
My lord, 2004 का वॉल्यूम 1 MPLJ पेज 285.
ठीक है, ये चारों जजमेंट उसी के ऊपर है।
Sir, and my lord, this judgment of 2004 volume 1 MPLJ squarely covers this case because in this case as well, my lord, it was an identical situation wherein the collector of stamps had given a finding that on the basis of the circle rates, the valuation of the building and the land was computed. Now the honorable court has been.
कब का मैटर है ये?
सर 2004
का 2002 का
में तो डिसाइड हुआ। फैक्ट्स क्या हैं इसके?
सर मैं बता दे रहा हूँ सर।
2001-2 में
25 में रीड पैरा 5
जी।
it is clear from the orders passed by the collector of stamps and the commissioner that only criteria adopted for making the valuation was register of valuation of the various sale deeds.
ठीक है, ये 1997 के कॉन्टेक्स्ट में है ये
सर।
ठीक है, ये जो गाइडलाइंस हैं ये इनको स्टैट्यूटरी फोर्स कब से मिला है? मध्य प्रदेश ये जो मूल्यांकन है इन गाइडलाइंस को स्टैट्यूटरी फोर्स कब से मिला है? फर्क ये है कि ये जो जजमेंट है ये इन गाइडलाइंस को स्टैट्यूटरी कलर मिलने के पहले का है।
ये 2000 में रूल्स आया है।
2000 में रूल्स है, मैं वही बता रहा हूँ, आपने नहीं बताया, वो आपका काम हम कर रहे हैं।
I am coming on that as well, my lord. My lord, there is one judgment, my lord, of 1990, my lord, that is 97 to MPLJ page 636, my lord.
1997
to MPLJ 636 आखिरी में लिखा है सर।
हाँ जी दीजिएगा
सर। इसमें the issue was sir to the 90।
मैं समझ गया आपकी बात सर। इशू तो ये है कि जब 2000 से यह गाइडलाइंस को स्टैट्यूटरी कलर दे दिया गया है, उसके बाद भी कैन बी से दैट दीज गाइडलाइंस आर नॉट बाइंडिंग।
Yes, my lord. With due respect, I submit. With due respect. Now, my lord, before that, my lord, to answer my lord's query, my lord, I would invite my lord's attention to the rules which are prepared under the Stamp Act for regarding valuation, my lord.
Yes.
My lord, जो second flag है वो local acts वाली किताब में आपकी।
कौन सा पैराग्राफ?
सेकंड फ्लैग सर।
सेकंड फ्लैग जी।
और उसके पहले एक बार 47A सर एक बार बस में
47 नहीं पढ़िए।
My lord, 47A2, my lord,
जी,
which my senior just read out. On receipt of a reference under section 1, the collector shall, after giving the parties a reasonable opportunity of being heard, and after holding inquiry, my lord, the word used is and after holding an inquiry, in the prescribed manner as may be prescribed, determine the market value of the property which is the subject matter of such instrument, and the duty as aforesaid.
ठीक है। Now what is
Now, my lord, the prescribed format, the prescribed manner is, my lord, these are the Indian stamp Madhya Pradesh Prevention of Undervaluation Rules, 1975.
Right.
Now, my lord, Rule 4 says, my lord,
जी,
procedure on receipt of reference or on a proposal to take action suo motu under section 47A.
जी,
If I may just read.
please.
A reference under subsection 1 of section 47A of the Act from registering officer shall be accompanied by a statement in Form 1 on receipt of reference under subsection 1 of section 47A of the Act from registering officer or where the collector proposed to take action suo motu under subsection 3 of the said section, he shall issue a notice in Form 2 or 3 as the case may be. मतलब वो है, फिर 3 is important मतलब। The collector may, if he thinks fit, record a statement of any person to whom a notice under sub-rule 2 has been issued. The collector may, for the purpose of inquiry, call for any information or record from any public office, officer or authority under the government or the local authority, examine and record statement of any member of the public officer or authority under the government or the local authority. C. Inspect the property after due notice to the parties concerned.
Yes.
Now, my lord, admittedly, he has not done anything out of these 3 conditions. Now, my lord, sub-rule 5. Rule 5 is further important. Principle for determination of market value. Now, my lord, why I say so, my lord, these rules are statutory rules. My lord, in a recent judgment of 2020, my lord, this honorable court has been pleased to hold that the only way of determining the market value when a reference is made under section 47A of the Stamp Act is only the statutory rules. Now, my lord, the collector shall, as far as possible, have also regard to the following points in arriving at market value. Now, my lord, case of land, my lord, this may be skipped, my lord, because essentially here the issue is that the building has been undervalued by us. So, my lord, for the land it is mentioned, for building, my lord, it is C. In case of building, the
Type and structure, locality in which
constructed, plinth area, area of construction, kind of material used, rate of description and fluctuation in rate. But further, any other features having bearing on the value, local rates, municipal or other taxes to which such building may be subject, and valuation of building with reference to taxation, records of local authority, etc. Now, my lord, rule 7, this is also important, my lord. The order which the collector will have to pass on a reference under section 47A. If I may read, my lord. The collector shall, after considering the objections and representation received in writing from the person to whom notice under sub-rule 2 of rule 4 has been issued, and those urged at the time of hearing, after examining the record before him, and 3, my lord, after a careful consideration of all relevant factors and evidence placed before him, pass an order. Now, my lord, these 3 words, next 3 words are important. Determining the market value of the properties and the duty payable on instrument, communicate the order to the parties and take steps to collect the difference in the amount of stamp duty. Now, in the present case, my lord, admittedly, my senior has read out the order of collector. What the collector has done, my lord, he has recorded our submission and he has reproduced the entire reference made to him under section 47A. Now, whereas, and he has not given or determined the market value, applying his own mind. Now, 7 sub rule 3 says, my lord, that he has to determine the market value. He cannot simply write that the market value which has been pointed out under in the reference order is correct. Now, with due respect, my respectful submission is, my lord, neither the collector has followed the provisions of sub rule 5. My lord, which are the principles for determination of market value. Neither, my lord, he has passed the order in the correct manner.
Yes.
As per sub rule 7.
Yes.
Now, my lord, under these rules, my lord, there was a provision that the market value shall be calculated on the basis of the circle guide rates. Now, my lord, this honorable court, while dealing with the validity of that sub rule, my lord, those rules were held to be ultra virus and therefore it was struck down. That is 97 to MPLJ 636.
1997 to MP 636. Yes.
There was rule 3A, my lord.
Rule 3A.
3A is reproduced at page 640.
Yes.
If my lord may get the last paragraph, 3A is quoted, my lord, in inverted comma. 3A, annual statement of rates of immovable property to be issued by the collector. Every district collector shall annually supply to the sub-registrar a copy of the statement showing average rates of land and buildings situated in the city, tehsil, corporation or local body of the district. Every registering officer shall cause a copy of the above statement to be affixed outside registration office. Every registering officer shall, when the instrument is produced before him for registration, verify in each case the market value of the land and building, etc., as the case may be, from the above statement, and if he finds that the market value as stated in the instrument is less than the minimum value prescribed by the statement, he shall refer the same to collector for determination of the actual market value of the property which is the subject matter of the instrument and the proper duty payable thereon, provided that where the market value has been stated in accordance with or more than the prescribed in the statement issued by the collector, but the registering officer has reasons to believe that the correct valuation of the immovable property be arrived without having recourse to local inquiry or extraneous evidence, he may after registering such instrument refer the same to collector for determination of the market value for the instrument and the proper duty payable thereon. Para 8, if I may read, if I, with my lord's permission, may skip para 7. While it is true that rule 3A does require the collector of every district to annually supply the sub-registrar a copy of the statement showing average rates of lands and buildings in every tehsil, corporation or local body of his district, the statement being only a statement of average rates of land and building postulates taking into account the highest and lowest rates prevailing in the areas or locality. It is thus clear that the rates relating to specific property are still required to be determined in accordance with the principles stated in Rule 5. It is thus manifest that the statement prepared under Rule 3 indicating the average rates cannot influence the decision of the collector in determining the market value of the property which is the subject matter of the instrument, as the specific value will have to be determined in accordance with the procedure prescribed in Rule 4 and the principle indicated in Rule 5. The contention of the learned counsel that the preparation of statement by the collector for its circulation to the sub-registrar indicating the average rates of land and buildings would influence the exercise of quasi-judicial powers of determination of the market value appears to be fallacious. As regards the contention of the learned counsel that the said rule acts in derogation of powers of the registering authority appointed under the Registration Act so and so, insofar as it exercised in accordance with subsection 1 of section 47A. Concerned, we find that the source of power for enacting the rule is stated to be under section 47A and section 75 of the Stamp Act. Section 75 of the Stamp Act grants power to the state government to make rules to carry out the purposes of the said act. The purpose for which Rule 3A appears to have been framed is to further the purpose and object of Section 47A. Thus, we have to see whether Rule 3A harmonizes with the purpose of Section 47A to further its object, or it impedes or curtails or abridges the power granted by the said section to the registering authority. A perusal of subsection 1 of Section 47A leaves us in no manner of doubt that the registering officer appointed.
उसके बाद तो 2000 के रूल्स आ गए,
यही
इसके
है।
बारे में क्या कहना है आपका?
उसके बाद 2000 का आ गया।
2000 के रूल्स आ गए, प्रॉपर्टी का ट्रांजैक्शन किस साल का है?
My lord, I have, my lord, एक second, my lord, if I may just submit, there's a judgment of the Honorable Supreme Court of 2004, my lord, after the rules, which says, my lord, that these rules cannot be taken to
2000 के रूल्स भी,
so 2000 के rules consider नहीं है, but
वही
what
तो
my
बोल रहे हैं।
respectful submission is,
2000 रूल्स का तो वायरस भी चैलेंज हुआ था एंड इट हैज बीन डिक्लेयर्ड टू बी इंट्रा वायरस।
my lord, I am not saying that there are no rules.
नहीं, ठीक है, ठीक है। हम आपसे सिर्फ यही जानना चाहते हैं कि जब ये 2000 के रूल्स आ गए, गाइडलाइंस आ गई, उसके बाद की क्या स्थिति बनी?
Now, what my respectful submission, my lord, that the market value when the case is under Section 47A referred to the collector, then those rules alone cannot be looked into for determining the market value for computing the deficit stamp duty.
चलिए, आपने क्या एविडेंस प्रस्तुत की थी?
My lord. My lord, before that, if one more legal argument, if my lord's permission,
बताइए ना।
my lord, my respectful submission is that under Section 47A, while the registering officer has to make a reference, my lord, he cannot do it in a routine manner in every case. My lord, 47A subsection 2 specifically says that the registering officer has to have reasons to believe, and there has to be an intention that the person who has presented the document for my lord, for registration has intention to evade the stamp duty, my lord. Now, for this, my lord, there are two judgments. 2009 volume 14 SCC, page 716.
जी। एंड दीजिए सर।
My lord would have para 19, para 52 and 53.
Para 19, yes.
If I may read, from a bare perusal of subsection 1 of Section 47A of the Act, it is clear that if the market value of any property, which is the subject matter of an instrument on which stamp duty is chargeable, as set forth in the instrument, is less than even the minimum value determined in accordance with the rules made under this Act, the registering official shall request the person to pay the deficit stamp duty and present the instrument again for registration. At the same time, it should be kept in mind that it is not enough for the authorities, for the purpose of invoking Section 47A, that the consideration amount stated in the instrument of sale is less than the prevailing market value, but they must be satisfied that there is an attempt of undervaluation. Now, my lord,
did you produce sale deeds which were executed for the properties in the same locality during that period to point out that the sale deeds were affected at a lesser value than the value determined by the collector of stamps?
with due respect, I submit we have not submitted. Now, what we have submitted, my
that
lord,
is the safest criteria.
My lord,
you submitted a report of some sub-engineer or
my
sub-engineer.
lord, my lord, two things were submitted, my lord. A report of a registered valuer was submitted, and my lord, an insurance of the building was done, my lord. So the insurance of the building was done on the basis of that registered valuation report.
The insurance of building was done prior to purchase or subsequent to
subsequent to purchase.
Subsequent to purchase तो आपके हिसाब से है। आप गाड़ी खरीदें, आप डिसाइड कर सकते हैं कितनी वैल्यू पे मुझे उसका बीमा कराना है।
My lord, that valuation report is there, that has not been disputed by the authority.
ठीक है। चलिए।
Now, if my lord, further, my lord, para 52 and 53 is in
yes, 52 and 53.
Here it was a case that whether the stamp duty would be payable from the date when the agreement was there or on the date when the deed is presented for execution.
So the law settled it.
नहीं, वही decide किया सर, पर उसमें ये बताया कि the reference could not have been made under section 47A because there was no intention to evade stamp duty. Since the stamp duty is to be charged on the consideration mentioned in the document under Article 63 of Schedule 1B of the Act, in case of an assignment of lease, the consideration mentioned on the document was adequate in respect of the time when the agreement of the transfer by way of lease was registered. It would be different question that when the said deed is to be executed, the value of the property has increased with the passage of time. The execution of the deed had not been delayed due to any fault on the part of the appellant, and therefore he cannot be held liable for intentionally suppressing the value of property. Moreover, as we have noticed, the appellant did not make any undue delay in executing the sale deed after the Noida authorities issued transfer memorandum. Therefore, considering the above circumstances, it would be unwise to say.
ये तो fact ही कुछ और है इसका.
My lord, what my respectful submission is that
somebody executed an agreement. Post agreement, he was required to take permission from the authority here, Noida authority. There was some time lag in obtaining those permissions. Now the Supreme Court says that for time lag which is not attributable to the seller or the purchaser, value as it stood on the date of the actual registration of the sale deed will be of no consequence. It will be the value which was operating or existing on the date of the agreement.
I bow down, my lord. And therefore, my lord, it has been held that the reference under 47A was not proper. Now, in the present case, my lord, the reference which is made under section 47A, the registrar does not make any observation and does not record the satisfaction that we have intention to evade the stamp duty. My lord, I'll read out that reference again. That reference order, my lord. Before that, my lord, two more citations. My lord, 2009 volume 7 SCC page 438.
2009 volume 7 SCC
page 438.
438. Yeah.
Para 13, my lord.
Yes.
Subsections 1 and 3 of section 47. My lord,
just a minute. Yes, subsections 1 and 3.
Subsections 1 and 3 of section 47A clearly reveal the intention of the legislature that there must be a reason to believe that the market value of the property which is the subject matter of the conveyance has not been truly set out in the instrument. It is not a routine procedure to be followed in respect of each and every document of conveyance presented for registration without any evidence to show lack of bona fides of the parties to the document by attempting fraudulently to undervalue the subject matter of the conveyance with a view to evade payment of proper stamp duty, thereby cause loss to the revenue. Therefore, the basis for exercise of power under section 47A of the Act is willful undervaluation of the subject matter of transfer with fraudulent intention to evade payment of proper stamp duty. Now, my lord, I'll read out, my lord, that although the state has not filed that reference order, I'll, my lord, supply it across.
Just a minute. ठीक जी नीचे का order.
This is the reference order, my lord, and the documents which were filed by us before the office.
Reference order is?
The first page, my lord.
First page, yes.
क्या ये हम दे रहे हैं, हम लाएंगे.
जी फिर क्या हुआ?
My lord, they only, my lord, on the basis of circulars they have done, my lord. Next, my lord, is that, my lord, my reply to the collector of stamps and the documents annexed by me, my lord. My lord, the valuation report and the insurance copy, my lord.
ठीक है फिर किस आधार पे किया इन्होंने वैल्यूएशन?
मतलब this is only on the basis of circle rates.
69 lakhs.
Sir,
69 lakhs का किया है ना इन्होंने
हाँ,
वैल्यूएशन?
मतलब it is मतलब my respectful submission is that a dispute only arises with regard to building. For land, my lord, there is valuation proper, my lord.
हाँ ठीक है, बिल्डिंग का ही बता रहे हैं।
हाँ, building, my lord, what I
क्या
respect.
कितने स्क्वायर फीट है, क्या है, पढ़िएगा जरा इनका पेज।
Sir, report valuation.
हाँ, मरवा एंड एसोसिएट सब समझे तो कैसे करते हैं ये वैल्यूएशन?
मतलब the second page, my lord, of the report.
यस, कहाँ है इसमें कंस्ट्रक्टेड एरिया का जिक्र?
ये है सर, ये सर लास्ट पेज पे है सर।
लास्ट पेज कहाँ है
सर? उसमें सर एक उन्होंने चार्ट बनाया है सर।
हाँ,
और ग्राउंड फ्लोर का कितना है, बिल्डिंग का फर्स्ट फ्लोर का कितना है
जी।
इफ माय लॉर्ड में गेट।
हाँ हाँ, आ गया ये
सर।
एक मिनट रुकिएगा। जी, कितना लिखा है इन्होंने?
सर इफ माय लॉर्ड में गेट द वैल्यूएशन।
हाँ हाँ, मिला ना। उसमें आपने एरिया लिखा है
सर,
कंस्ट्रक्टेड एरिया।
नहीं सर, उसके बाद सर उन लोगों ने हर फ्लोर का अलग अलग दिया सर।
कहाँ दिया, वही तो समझना चाह रहे हैं।
कौन सा साहब को ये दे?
नहीं, इसमें जो कागज लगा हुआ है
सर,
वैल्यूएशन रिपोर्ट का, बिल्टअप एरिया 31,200
सर, वैल्यू ऑफ द बिल्डिंग फॉर
स्टोरीड बिल्डिंग।
सर
बिल्टअप एरिया लिखा है ना इन्होंने?
उसके बाद एक और है सर।
उसके बाद क्या है?
मतलब जस्ट बिफोर दैट इंश्योरेंस कंपनीज ऑर्डर, मतलब द
ये
सर्टिफिकेट
मरवा एसोसिएट्स, ये
सर वैल्यूएशन मतलब
जी। इसमें
लुकिंग टू द अबव।
इन्होंने मेज़ाइन का 1200 फुट उड़ा दिया।
सर मेज़नाइन तो उस समय बना नहीं था सर, वी हैड मेड अ स्पेसिफिक प्रेयर।
चलिए चलिए
सर,
मेज़ाइन बिल्डिंग में बाद में बन जाता है क्या?
सर वो लंबी लॉबी थी सर, फर्स्ट और
अच्छा, चलिए, आई डोंट नो।
वैल्यू ऑफ द बिल्डिंग फॉर द ग्राउंड फ्लोर माय लॉर्ड, एरिया इज 8500 स्क्वायर फुट।
ये 360 रुपीज स्क्वायर फीट कहाँ से लेकर आए ये तो बताएं।
मतलब दैट इज फॉर द वैल्यूअर माय लॉर्ड। ही मतलब
अरे you are standing in the footsteps of the valuer. You are relying on his report. You will have to seek instructions and
my lord,
guide this court that on what basis this valuation has been drawn by the valuer.
Yes, my lord. I'll apprise my lords of that. My lord, what had happened, my lord? The present respondent before my lords, my lord, they are contractors, government contractors as well, my lord. No, they were performing another work of a different locality on that particular year, my lord. Then it has been stated that in the year 2002, when the deed was presented for registration, my lord, the construction cost was 300 rupees per square foot, my lord.
ठीक है।
Even that was produced, my lord.
एक्चुअली ये राइट टाउन का है और इस समय वहाँ इन्होंने विजयनगर का जो कंस्ट्रक्शन रेट था उसको कंपेयर करके यहाँ पे दे दिया।
कंस्ट्रक्शन पूरे जबलपुर में कहीं भी करेंगे उतना ही पड़ेगा।
विजयनगर में कुछ भी नहीं था
सर, सीमेंट और रेत के रेट पूरे जबलपुर में उतने पड़ेंगे, कहीं और अलग नहीं पड़ेंगे सर।
नहीं, सीमेंट और रेत के रेट के अलावा जो है
सर, दिस 360 रुपीज इज कंस्ट्रक्शन कॉस्ट।
हाँ, ठीक है।
My senior, my lord, my lord, his intention is to refer to the guidelines. I am not on that.
अच्छा,
But this is the valuation of the building.
ये
My lord, what my respectful submission is.
थोड़ा बहुत कंस्ट्रक्शन का हमें अनुभव है
सर,
जितना फ्लोर बढ़ते जाता है, आप भी करा रहे हैं कंस्ट्रक्शन है, उसमें तो 10% पर फ्लोर जो है लिफ्टिंग चार्जेस बढ़ते जाते हैं।
My lord, what my
300 रुपए कंस्ट्रक्शन का होता है कि सीधा सीधा
forget about the case
नहीं,
for a
my lord,
minute.
I go down, my lord. I understand that. My lord,
नहीं नहीं, ऐसा होता है नहीं, वो लिफ्ट का चार्जेस लेता है ठेकेदार।
सर ठेकेदार लिफ्ट का चार्जेस नहीं लेता सर, वो सामान
लिफ्ट
ऊपर
मतलब वो
सामान
सामान
ऊपर
लिफ्ट,
ढोने का
हाँ
चार्ज।
वो भाई जितना फ्लोर बढ़ता जाएगा उसमें 10% पर फ्लोर जो है वो लिफ्ट चार्जेस बढ़ाता जाता है
सर
ठीक है, यहाँ हर फ्लोर में कम होते जा रहे हैं।
सर माय रिस्पेक्टफुल सबमिशन, जो वैल्यूएशन होता है इट इज नॉट माय लॉर्ड एज पर द रेट्स माय लॉर्ड, व्हाट हैपेंस माय लॉर्ड, द एज ऑफ द बिल्डिंग माय लॉर्ड, द कंस्ट्रक्शन क्वालिटी ऑफ द बिल्डिंग माय लॉर्ड, द रजिस्टरिंग ऑफिसर माय लॉर्ड हिमसेल्फ हैज रिकॉर्डेड कि हम बिल्डिंग का इंस्पेक्शन करने गए थे और पूरी दीमक लगी हुई थी, पूरी उसकी बीम सड़ चुकी थी, मतलब ही हैज मेंशन्ड इन हिज रेफरेंस ऑर्डर।
लकड़ी वर्क, सीलिंग वर्क की लकड़ी।
My lord, there is one more judgment, my lord, which says that while calculating the valuation of building for payment of Stamp Act, my lord, the age and the construction, the type of construction, everything has to be seen.
जी जी।
My lord, my respectful submission is, my lords have just gone through the order of the collector. My lord, the collector has not even discussed about these
ठीक है।
engineer reports and the insurance company's registration certificate.
कौन से इंजीनियर की रिपोर्ट कंसीडर करनी
ये
थी?
Marwa Associates, my lord, this was filed by us with the collector.
जी जी। So did you express before the collector that you should be given an opportunity of hearing through this valuer who has produced this report?
My lord, I humbly bow down, my lord. It is, my lord, the collector is duty bound under Rule 5.
That is what you say.
My lord, the collector has not even, my lord, called for the report from his own experts, my lord. My lord, if he had, my lord, if he had to disregard this report, my lord, he could have made an assessment. But he has also not made any assessment. There is no finding to that effect by the collector.
Anything else?
My lord, this judgment, if my lord would have a kind reason. 96 volume 4 SCC page 657.
1996 for SCC
657. My lord, I have supplied
657.
ठीक 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 ठीक। इसका WP नंबर बाबू साहब, एक किताब और निकाल दीजिए प्लीज, 16 का 2 MPL जी। सोलह का तो जल्दी निकाल।
जी, किस पैरा को रिफर कर रहे हैं आप?
मतलब
1990
पैरा 4 में
पैरा 4 पढ़िएगा।
We have carefully examined the orders of the first respondent. Noticeably, the house is built on a very small area, that is 68.84 square yards, only in a town which is not metropolis. Presumably, the smallness of the area would not suggest the same by itself to be a costly property or be situated in a prestigious or posh locality where the upper class would rub shoulders to acquire it. Secondly, it's being situated in an area which is so close to Samrat Vikram colony, said to be a decent locality where people of high income group reside, does not by itself make it a part thereof. We are doubtful whether the said factum of closeness of by itself would cast any reflection on the price of the property in question. Seemingly influenced by the factor of close proximity with so and so colony, the assistant commissioner stamps for one does not know how determine the monthly rental value of the property at rupees so and work out the price of the house on that basis. Despite that, the Tehsildar at a subsequent stage reported that the annual rental value of the house was rupees so, whereas for house tax purpose it was recorded as 840 per annum. The first respondent, ignoring the same, worked out the monthly rental of the property at so and so on the basis that the average cost of construction of building in the year 1992 was about rupees 400 per square yard, inclusive of land cost. This figure too was arrived at one knows not from where, without determining the age of building, the quality of construction, and citing appropriate instances. The approach of the authorities, to say the least, was highly vain, casual, and unsatisfactory, and dehoars any constructive material on the basis of which one could have said that the decision arrived at by the first respondent was fair and reasonable. We cannot approve such an assumptive posture of the respondent in treating the appellant as an evader. We must therefore upset the impugned order of the first respondent and the proceedings for the supposed deficient stamp duty, but confining the end result to the facts and circumstances of the instant case when the valuation fixed is at least not below the minimum prescribed. My respectful submission is, my lord, that without construing, my lord, all these aspects, the nature of the building, my lord, only on the basis of the reference made under section 47A, my lord, the collector has passed the order. Now, if I may just
आराम से 4:30 तक आपका टाइम है.
My lord, coming back to, my lord, the question raised by my lords, my lord, to me, that what will happen to the 2000 rules, my lord? My lord, the validity of those rules was under challenge. Now, it has been decided in 2016 volume 4 MPLJ.
2016
volume 2 MPLJ, page 236.
236
236 rules, valuation वाले.
क्या कहा इसमें?
But page 56 is important. Para 56, sorry. My lord, this is vis-a-vis rules 47A, my lord, of the Stamp Act. If I may read, my lord. The decision of the Supreme Court in the cases of Siddharth Saraogi, A.K. Roy, Marathwada University, and Kunj Lal Bihari and others pressed into service by the petitioner will be of no avail. For we have held that the guidelines issued by the valuation committee are in furtherance of rules of 1975 read with the rules of 2000 and not a dispensation created thereunder, so as to invoke the principles of delegatis non postes delegati. Moreover, the delegation is to evolve norms for determination of minimum value as has been provided in section 47A of the Act. It is therefore not a case of excessive delegation or a matter conferring parallel powers in the valuation board to evolve norms related to determination of market value, as is contended. Further, the minimum value prescribed by the valuation board merely serves as a guideline and non-binding on the registering authorities. The registering authorities are free to determine the market value of the property as per the principles set out in the Act read with rules of 1975. That is for rule 456.
Yes.
Rather obliged to do so. So, my lord, my respectful submission is, my lord, that despite the rules of 2000, my lord, the collector is bound to follow the rules of 1975.
Yes.
My lord, which admittedly he has not done.
जी. ठीक.
Yeah. My lord, there is one judgment, my lord, of the year 2022 by the Honorable Gwalior Bench, my lord. And while dealing section 47A, etc., my lord, the para 16 is important. My lord, the 2075 rules, my lord, they have been supplemented by the rules of 2018, my lord. However, there are para-material provisions on it.
बताइए.
Para 16, if I may read.
Yes.
With regard to the argument advanced by the learned senior counsel regarding ascertainment of the market value of the property purchased and registered in the 2014 on the basis of the circumstances prevailing in the 2017 on the basis of spot inspection done in that year, that too without giving an opportunity of hearing, was not justified. Thought the guidelines for commercial use prevailing in 1415 were made the basis of calculation of the market value. Appeals to reason for the fact that thought as held above that under 48B of the Indian Stamp Act read with provisions of the Madhya Pradesh determination of market value of instruments and disposal of stamp rules 2018 collector of stamps can ascertain the market value of the property for ascertaining deficiency in stamp duty or registration charges, which is subject matter of such instrument, but only in accordance with the procedure prescribed in the rules of 2018. And since the procedure as envisaged in rule 2018 had not been followed, no opportunity of hearing had been granted to the petitioner, the determination of market value of the property is vitiated. 2018 rules, the provisions are para material to the 75 rules.
Yes.
So the only manner in which the market value is to be ascertained is as per the rules of 75 and in no other manner. If मालूट में ग्रांट्स में लिबर्टी टू रीड 2004 वॉल्यूम 1 एमपीएलजे मालूट जो सबसे पहला जजमेंट दिया था।
हाँ बताइए ना।
4 पेज
2004 का कहाँ है, निकालिए। 2004 का वॉल्यूम 1 एमपीएलजे
मालूट।
यस
मालूट पेज 285
यस
but para 5 I had read malot.
Yes.
But if malot would come to para 11 malot at page 290.
Yes.
If I may read malot.
जी.
Section 47A has been considered by the apex court and various high courts, and it has been held that the basic valuation register cannot be the basis to determine the market value. Thus, in my opinion, the orders passed by the collector of stamps as well as commissioner were wholly unrealistic and bad in law, and Board of Revenue has passed the order P6, making the valuation which cannot be said to be impermissible or without jurisdiction. Apart from the fact that there was no basis for making the valuation made by the collector of stamps as well as commissioner, it is clear that the property is situated in sublane. The constructed structure was wholly dilapidated as found in the inspection report also. The comparable sales were not looked into. In no case the valuation register could be the safe criteria to determine the market value as adopted by the collector of stamps and commissioner. All the facts and circumstances were not taken into consideration by the collector of stamps and commissioner, which have been adverted to by the Board of Revenue.
जी. ठीक.
The two judgments, if malot would direct malot, they are only with respect to at the circle rates, they are not conclusive.
हाँ ठीक है, तो आप बता चुके इतने सारे
judgment. Now, if malot would just have a perusal of the order of collector again.
जी जी. ये 2004 में हाई कोर्ट ने भी कुछ और कहा है, वो आप मिस कर गए शायद.
सर
पढ़िएगा.
सर
High Court cannot substitute the valuation until and unless it is shown to be wholly perverse, unrealistic. The finding of fact recorded by the Board of Revenue is proper. Now you'll have to show that the basis on which Board of Revenue has arrived at a conclusion is correct and that does not call for any interference. अब Board of Revenue का order पढ़िए, उससे ये बताइए कि इन्होंने valuation कहाँ से लेकर
नहीं,
आई.
my lord, what my respectful submission is, my lord, the Board of Revenue has, after considering, my lord, जो उनने दूसरे judgments लगाए कि revenue निर्णय, my lord, I will not rely on that, my lord, but the Board of Revenue has held that the
Board of Revenue was required to show that the valuation arrived at by the collector of stamps is perverse. For that, they should have relied at least on the valuation put forth by you in the hands of a chartered valuer.
But that has been relied.
No, that has not been. That is.
If I'll
आप पढ़िए ना, Board of Revenue का order पढ़िएगा. कहाँ लिखा है?
मैं read from page 3 my lord where the judgments have been referred, or my lord I'll directly read the conclusion my lord.
नहीं, जहाँ जहाँ से आप पढ़ के मुझे बता सके
Sir.
वहां से पढ़िए कि बोर्ड ऑफ रेवेन्यू ने, क्योंकि ये ऑर्डर तो मुझे बहुत क्रिप्टिक दिखाई दे रहा है। बोर्ड ऑफ रेवेन्यू ने, मतलब आई एम सॉरी टू से, बट इट अपीयर्स दैट ही हैज साइंड ऑन अ डॉटेड लाइंस because there is no discussion that from where he has come to a conclusion that the valuation made by the collector of stamps is inappropriate. पढ़िएगा इसको, आप बताइएगा।
Just one
शुरू से पढ़ लीजिए आप।
Just one statement my lord, that my lord, my respectful submission is that the collector has not done any valuation my lord.
कलेक्टर नहीं, जो उन्होंने रेफरिंग अथॉरिटी है उसने वैल्यूएशन करके भेजा। ठीक है, मैं ये पूछ रहा हूँ कि बोर्ड ऑफ रेवेन्यू ने, यू आर सपोर्टिंग द ऑर्डर ऑफ बोर्ड ऑफ रेवेन्यू। Let us see that how board of revenue has dealt with the matter.
My lord, before that, just two statements, my lord. I'll read it, my lord, as my lord would direct. My lord, first, my lord, under section 47A, the registering authority could not have made any valuation. One. And my lord, second,
आप कर चुके, कह चुके आप। अब बोर्ड ऑफ रेवेन्यू पर आइए। बोर्ड ऑफ रेवेन्यू ने क्या कहा? क्योंकि 2004 का एक MPLJ ये कहता है कि हाई कोर्ट कैन नॉट सब्स्टिट्यूट इट्स ओन वैल्यूएशन।
yes.
तो अब बोर्ड ऑफ रेवेन्यू का वैल्यूएशन अपहेल्ड करने के लिए हमें ये देखना पड़ेगा कि बोर्ड ऑफ रेवेन्यू ने किस डॉक्यूमेंट्री एविडेंस के ऊपर रिलाय कर यह निर्णय लिया है कि 12 लाख रुपए की स्टैंप ड्यूटी वापस कर दी जाए।
बोर्ड ऑफ
पढ़िएगा, इसको पढ़िएगा।
पैरा पेज 4 से पढ़ लेते हैं सर।
शुरू से पढ़िए ना, इसको शुरू से पढ़ के समझते हैं ना, इससे फिर बार बार लिंक करने में दिक्कत नहीं आएगी।
यह अपील आयुक्त जबलपुर के अपील प्रकरण सो एंड सो में पारित आदेश दिनांक 26/4/3 के विरुद्ध भारतीय स्टैंप अधिनियम की धारा 47A के अंतर्गत प्रस्तुत की गई है। प्रकरण का मतलब few words are in missing my lord, if I may just read it, I'll seek liberty my lord to read it my lord। जैसा समझ आ रहा है
विवरण यह है कि
अपीलांट के कलेक्टर ऑफ स्टैम्प जबलपुर ने विवादित संपत्ति का मूल्य 4,53,13,000 रुपए नियत किया और कम मुद्रांक शुल्क 12,59,000 रुपए जमा करने का आदेश दिया। अपीलांट ने अंडर प्रोटेस्ट कम मुद्रांक शुल्क को जमा कर प्रथम अपील आयुक्त जबलपुर संभाग के समक्ष की। उक्त अपील में कलेक्टर ऑफ स्टैम्प के निर्णय को उचित ठहराते हुए अपील निरस्त की गई। विद्वान आयुक्त जबलपुर द्वारा पारित आदेश दिनांक 26/4/3 के विरुद्ध यह अपील इस न्यायालय के समक्ष प्रस्तुत की गई है। उप पंजीयक जबलपुर संभाग तथा विक्रेता रिस्पोंडेंट क्रमांक 2 सूचना पश्चात उपस्थित रहे, अतः उनके विरुद्ध एक पक्षी कार्रवाई की गई। कलेक्टर ऑफ स्टैम्प का अभिलेख का अवलोकन किया। अपीलांट के विद्वान अभिभाषक श्री राव ने यह तर्क प्रस्तुत करते हुए व्यक्त किया कि अपीलांट द्वारा नियम अनुसार देय स्टैम्प शुल्क विक्रय पंजीयन हेतु जमा किया है, फिर भी उप पंजीयक जबलपुर ने मनमाने तौर पर कम मुद्रांक शुल्क होना बताकर मूल्यांकन हेतु प्रतिवेदन कलेक्टर ऑफ स्टैम्प को भेजा। विद्वान अधिवक्ता ने अपने तर्क में कहा कि उप पंजीयक ने मनमाने तौर पर उक्त संपत्ति व्यापारिक क्षेत्र में होना मानकर प्रतिवेदन भेजा। कलेक्टर ऑफ स्टैम्प के समक्ष अपीलांट ने नगर निगम जबलपुर द्वारा जारी वाणिज्य मार्ग की सूची पेश की, जिसमें अपीलांट की संपत्ति सुभद्रा कुमारी चौहान मार्ग पर होना अभिव्यक्त किया तथा उक्त मार्ग वाणिज्यिक मार्ग घोषित नहीं है। विद्वान अभिभाषक ने यह भी व्यक्त किया कि उप पंजीयक को स्वयं कोई मूल्यांकन करने का अधिकारिता नहीं है तथा उप पंजीयक को भवन के निर्माण, उसके अवक्षण से संबंधित अनुभव एवं तकनीकी ज्ञान भी नहीं है। उप पंजीयक ने विवादित संपत्ति जिसे क्षेत्र में स्थित है के विगत 5 वर्षों के विक्रय पंजीयक विलेखों को भी अवलोकन न कर मनमाना प्रतिवेदन भेजा। कलेक्टर ऑफ स्टैम्प ने विक्रेता को कोई सूचना पत्र विहित प्रारूप में जारी नहीं किया। उप पंजीयक ने गाइडलाइन के आधार मानकर मुद्रांक शुल्क से को कमी बताई है। वह माननीय उच्च न्यायालय द्वारा AIR 97 MP बाला प्रसाद मालोड जजमेंट विच आई रेड आउट पेज 218 के अनुसरण में मेरा ध्यान आकर्षित किया, जिसके अनुसार वह अकृत एवं शून्य है। कलेक्टर ऑफ स्टैम्प ने माननीय उच्च न्यायालय के न्याय दृष्टांतों को,
एक मिनट यहाँ पॉज करिए। जो इश्यूज बनते हैं वो ये है, पहला यू हैव टू, बोर्ड ऑफ रेवेन्यू सेज that you had deposited this amount of 12,59,000 under protest.
Yes ma'am.
You will be required to show कि ये प्रोटेस्ट में जमा किया था, इसका कौन सा कागज है।
मतलब रिकॉर्ड में अगर नहीं होगा तो इफ आई में सप्लाई
नहीं, रिकॉर्ड में जो है उसी को
बताइए। तो रिकॉर्ड है जो कलेक्टर और बोर्ड ऑफ रेवेन्यू और कमिश्नर के सामने जो रिकॉर्ड था उसी का हिस्सा है सर।
आप दिखाइएगा कहाँ है वो अंडर प्रोटेस्ट, इस तारीख को जमा किया आपने।
चालान है सर मेरे पास,
उसमें लिखा है अंडर
प्रोटेस्ट लिखा है सर।
ये जो दस्तावेज आपने दिए थे इन्हीं में है क्या?
इनमें नहीं है सर, अलग से है मेरे।
हाँ, क्योंकि मैं ओरिजिनल बुला के वेरीफाई करूंगा उसको।
मैं सर
तो दूसरा इशू
मतलब
इन्होंने कहा कि विद्वान अधिवक्ता ने अपनी तरफ में कहा कि उपपंजीयक ने मनमाने तौर पर उक्त संपत्ति व्यापारिक क्षेत्र में होना मानकर प्रतिवेदन भेजा है।
सर
वो प्रतिवेदन में पढ़िएगा व्यापारिक क्षेत्र में माना है कि व्यापारिक संपत्ति माना है?
क्षेत्र माना है सर।
कहाँ है पढ़िएगा वो प्रतिवेदन?
प्रतिवेदन सर मैंने दिया है।
आपने दिया था ना? प्रतिवेदन में क्या लिखा है?
उसमें मतलब सेकंड पेज मतलब
हाँ सेकंड पेज।
स्टेडियम के पास कॉर्नर स्थित मुख्य द्वार साइड रोड
की तरफ
रोड
रोड की ओर एक आपात द्वार
भवन पुराना होने के कारण
मरम्मत का कार्य जारी, बाहर से स्ट्रक्चर
पूर्वता कोई परिवर्तन नहीं।
ये कहाँ से आई है ये फाइंडिंग कि ये व्यावसायिक क्षेत्र में है? क्योंकि बोर्ड ऑफ रेवेन्यू ने इसके ऊपर काफी एम्फेसिस दिया है
सर,
इसीलिए मैं पूछ रहा था। इसमें तो कोई व्यावसायिक क्षेत्र लिखा नहीं है,
मतलब
और आपने जो अपना दिया है नावेदक लिखित कथन करता है
सर,
उसमें भी आपने ये बोला है कि उसमें कोई रेस्टोरेंट नहीं चलता, इसलिए जो है वो व्यावसायिक नहीं है, आवासीय दर से लिया जाए।
सर
आपने ये कहीं इसमें तो ये फाइंडिंग जो है परवर्स है ये बोर्ड ऑफ रेवेन्यू की कि कमर्शियल क्षेत्र में मानते हुए
that is not the ground on which the board of
अरे आई एम जस्ट ट्राइंग टू अंडरस्टैंड द ऑर्डर एंड I am being very open so that you may also understand that what is going on in my mind.
I understand.
तो ये जो कह रहे हैं क्योंकि उन्होंने उसके कह दिया उप पंजीयक ने विवादित संपत्ति जिस क्षेत्र में स्थित है कि 5 वर्षों के विक्रय का भी अवलोकन न कर मनमाना, तो ये तो आपने पहले ही मान लिया कि आपने कोई विक्रय अभिलेख प्रस्तुत नहीं किए थे, ठीक है? तो ये जब प्रस्तुत ही नहीं किए तो वो कहाँ से उनको कंसीडर करता? ठीक
If I may just submit to that.
एक सेकंड एक एक करके चल रहे
सर।
तो ये जो वाणिज्यिक मार्ग घोषित नहीं है ये जो फाइंडिंग आ रही है
सर,
और व्यापारिक क्षेत्र में माना, ये तो व्यापारिक क्षेत्र में नहीं माना, ये भी गलत है ये फाइंडिंग।
वो सर अगर मैं because the entire record of collector and commissioner is not there my lord, therefore I am submitting my lord how my lord जो rates जिस बेस पे उसने रेफरेंस किया है सर रजिस्ट्रार साहब ने, वो रेट्स कमर्शियल एरिया के रेट्स थे सर, वो रेट्स मेरे पास हैं अभी भी।
अच्छा दिखाइएगा।
साहब बाबू साहब ये साहब नंबर 4 है सुभद्रा कुमारी चौहान, वो स्क्वायर मीटर्स में है सर। नंबर 4 पे सर सुभद्रा कुमारी चौहान,
राइट डाउन।
दिस इज इन स्क्वायर मीटर्स my lord, they have calculated in square foot।
हाँ हाँ ठीक है, ये स्क्वायर मीटर में है ये
सर।
आवासीय के 6456 2001-2 का है ना ये
सर,
और ये है अन्य सड़क पर 3551, ठीक है। 6456 divided by 10.076, तो उससे भी कम रेट लिया इन्होंने, व्यवसायिक का रेट तो लिया ही नहीं इन्होंने। 525 रुपए लगाया है इन्होंने।
1200 660 और 525।
नहीं 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 नहीं, वो भूखंड का 660,
शेष भूखंड
का 660 लगाया है।
660
और उसका तो डिस्प्यूट ही नहीं है, बिल्डिंग का डिस्प्यूट है
मेजरली सर, बिल्डिंग का।
हाँ चलिए।
उसमें भी हर फ्लोर पे 20% 25% की कमी भी की गई।
हाँ ये देख लिया चलिए।
Not what my submission
बिल्डिंग रेट्स कहाँ है इसमें?
हाँ सर,
बिल्डिंग रेट्स
सर उसके पीछे हैं।
हाँ
Now the question would be my lord that whether the registering authority, my lord, who is not an expert, who is not an engineer, could he have made the inspection, my lord, and could he have applied, made this reference only on the basis of these guidelines, my lord, when they are not binding,
Yes.
or do not have a statutory force, or they, my lord, they can be taken into consideration for determining the market value.
Yes.
My lord, can that be the basis, my lord? And can, my lord, this is what the Board of Revenue has held, that this cannot be the basis, and he was not an expert nor he was an engineer.
जी.
But
ठीक. जी. आगे बढ़े बोर्ड ऑफ रेवेन्यू का ऑर्डर.
I read from the judgment, thereafter from the judgment, where the judgment is quoted. AIA 97 के अनुरोध में मेरा ध्यान आकृष्ट किया, जिसके अनुसार वे आकृत एवं शून्य है. कलेक्टर ऑफ स्टैम्प ने माननीय उच्च न्यायालय के न्याय दृष्टांतों के विपरीत जाकर स्वयं कोई मूल्यांकन संबंध जांच नहीं की, ना ही उप पंजीयक को आहूत कर गाइडलाइन एवं प्रतिवेदन को सिद्ध ही किया है. कलेक्टर ऑफ स्टैम्प ने स्वयं ना तो स्थल निरीक्षण किया, ना ही अपीलांट द्वारा पेश दस्तावेज पर कोई ध्यान दिया. अपीलांट ने तकनीकी रिपोर्ट मूल्यांकन के संबंध में पेश की है, उसे भी अनदेखा कर पंजीयक के प्रतिवेदन से सहमति जताते हुए आदेश पारित कर दिया. उनका तर्क है कि प्रथम अपीलीय न्यायालय ने उपरोक्त तर्कों पर विचार न कर अपील निरस्त कर गंभीर त्रुटि की है, अतः अपील स्वीकार की जावे व कलेक्टर ऑफ स्टैम्प जबलपुर एवं आयुक्त के आदेश निरस्त किए जावे.
ये गलत कह रहे हैं, स्थल निरीक्षण नहीं किया.
सर कलेक्टर ने नहीं किया सर. Let my friend read out the order of collector, my lord, that the collector has
कलेक्टर ऑफ
conducted.
स्टैम्प्स ने.
Sir,
ठीक है, उसको देखेंगे. यस जी.
मैं read further.
हाँ पढ़िए.
मैंने अभिलेख का अवलोकन कर किया और अपीलांट के विद्वान अभिभाषक से तर्क पर मनन किया. अभिलेख के अवलोकन से स्पष्ट है कि उप पंजीयक जबलपुर ने मुद्रांक की कमी का प्रतिवेदन कलेक्टर ऑफ स्टैम्प को भेजा. कलेक्टर ऑफ स्टैम्प द्वारा विधिवत रूप से मूल्यांकन करने के लिए कोई प्रयास नहीं किया गया. कलेक्टर ऑफ स्टैम्प ने मूल्यांकन हेतु विगत 5 वर्षों के विक्रय से संबंधित विलेख नहीं देखे. But assuming that I have not submitted, my lord, it was duty bound under the statutory rules to call for the record and look into it.
कहाँ है वो, कहाँ प्रोविजन है वो बताइए.
My lord, rule 4 and 5, my lord, where he can call for evidence any document as he deems.
1975 के रूल्स ना.
Sir, it does not specifically says 5 साल का रिकॉर्ड.
एक सेकंड देखते हैं. रूल 4 क्या कहता है
सर? रूल 4 में
4 में कहाँ है वो 5 साल की देखेगा.
5 साल का लिखा है, ऐसा नहीं लिखा है सर. बट ही हैज टू अडॉप्ट हिज ओन प्रोसीजर, माय लॉर्ड. बट इट इज हिज रेफरेंस, माय लॉर्ड. He has to satisfy that the reference made to him, and for determining the value, he has to ascertain, follow the principle of for determination market value under Rule 5.
ठीक.
This he has not done.
ठीक है, ओके. चलिए.
मात्र गाइडलाइन के आधार पर मानकर उप पंजीयक के प्रतिवेदन से सहमत होकर आदेश पारित किया गया, जो न्याय के प्राकृतिक सिद्धांतों के विपरीत है. विद्वान अभिभाषक ने मेरा ध्यान 2001 रेवेन्यू निर्णय पेज 21 विजय कुमार सो को आकर्षित किया, जिसमें इस सिद्धांत प्रतिपादित किया गया है. स्टाम्प अधिनियम सो धारा 47A क मध्य प्रदेश लिखितों के न्याय मूल्यांकन के निवारण नियम 1975 नियम 5 मूल्यांकन का निर्धारण विक्रेता तथा क्रेता दोनों को सूचित किया जाना चाहिए. साक्ष्य के अभिलेख के बिना केवल निरीक्षण के आधार पर निर्धारण नहीं किया जा सकता. He has not adduced any, no evidence was adduced before the collector. He has not collected any evidence. This is what my respectful submission is. इस प्रकार मैं पाता हूं कि अधीनस्थ न्यायालयों द्वारा पारित आदेश विधि सम्मत न होने से स्थिर रखे जाने योग्य नहीं है. अभिभाषक ने मेरा ध्यान 1992 रेवेन्यू निर्णय पेज 302 की ओर भी आकृष्ट कराया गया.
रिमांड करना चाहिए था. अगर इतनी सारी खामियां थी, then the Board of Revenue should have remanded the matter.
My lord, my respectful submission is that the board has found that the my lord,
there are two aspects.
My lord.
One is that the collector of stamps failed to observe certain procedures and failed to make compliance of the 1975 rules. Then what was the duty of the Board of Revenue? Because it could not have determined the valuation on its own. Therefore, it should have remanded the matter back to the collector of stamps for following the procedure and determine the value in accordance with the law. Therefore, this gives me an impression that the Board of Revenue has signed on dotted lines. It has not adhered to any principles. It has not dealt with भाई सिंपल सा प्रिंसिपल है. अगर आप एग्री नहीं कर रहे और उसमें खामियां हैं तो मैटर रिमांड होगा.
Sir, if I may just submit, my lord, I humbly bow down to my lord's view, my lord. If I just submit one thing, my lord. My lord, if my lord would just have a perusal of section 47A and whether, my lord, reading further to this judgment, to this order of the Board of Revenue, my lord, whether, my lord, the registering authority could have made a reference under section 47A, my lord.
It has not quashed the order saying that the reference could not have been made by the registering authority. Therefore, the order of collector.
My lord, they have stated, my lord, that he is not an expert.
Again, he was required to remand the matter to the collector of stamps, saying that he should conduct an independent inquiry and pass orders without getting influenced by the reference made by the registering authority.
That authority is not with the Board of Revenue for suo moto taking action, my lord. It is only with the collector under section 47A3.
He is the chief controller of the revenue, Board of Revenue, President Board of Revenue, and therefore by implication all the members of the Board of Revenue are the chief controlling revenue authority of the state. And this matter, since deals with the revenue of the state, it has to be dealt in accordance with law.
I bow down, my lord. Now, what my respectful submission is, my lord. Just two more arguments, my lord. Just last two arguments. Whether, and I'm again repeating, I'm sorry, my lord. Whether the registering authority was competent to refer the matter, my lord, or whether, my lord, he could have made an assessment on his own. Not being an expert, not being an engineer. Now, my lord, since there was no report of an expert either by the collector or by the registering authority, my lord, we submitted a report on the contrary. Two reports, my lord, one of the insurance company and of the registered valuer. And therefore, on that basis, my lord, the order has been quashed. ये आखिरी में लिखा है सर बस एक दो लाइन
हाँ पढ़िए ना पढ़िए.
उपरोक्त दी गई न्याय दृष्टांतों में अपीलांट पर जो स्टैंप एवं मुद्रांक शुल्क अधिरोपित किया गया वह न्याय संगत ना होकर नैसर्गिक न्याय सिद्धांतों के विपरीत है. अपीले न्यायालय विद्वान आयुक्त ने भी उनको द्वारा पारित आदेश स्थिर रखा है. मेरे मत में उपरोक्त दिए गए न्याय दृष्टांतों के दृष्टि में रखते हुए उपरोक्त अनुसार पंजीयन एवं मुद्रांक शुल्क नहीं लगाया जा सकता. यह भी उल्लेखनीय है कि सब रजिस्ट्रार एक तकनीकी अधिकारी नहीं है. उसे निर्माण के पूर्व अनुभव ना होने से वह संपत्ति का वास्तविक मूल्य नहीं निकाला जा सकते.
नहीं तो वो तकनीकी अधिकारी नहीं है
सर.
तो ऐसा उन्होंने फिर ये क्यों कह दिया? आगे बढ़िएगा
सर.
नियुक्त सरकार को नियुक्त करना चाहिए. व्हाट इज द अथॉरिटी ऑफ बोर्ड ऑफ रेवेन्यू टू एडवाइज द गवर्नमेंट?
नहीं, नॉट द गवर्नमेंट बट द कलेक्टर.
इसमें पढ़िएगा ना
सर.
बाजार मूल्य के क्या लिखा है?
इसके लिए
निर्धारण हेतु
सर
एवं अवश्रवण को निर्धारित कर मूल्यांकन हेतु शासन को मूल्यांकन करने वास्ते तकनीकी अधिकारी नियुक्त करना चाहिए ताकि न्यायिक निराकरण सुविधा हो. तो ये what is their authority to advise the government and where from they get this advisory jurisdiction?
Now, my lord, just to sum up, my lord, my respectful submission is, my lord, that
हमारी बात का जवाब तो दे दीजिए.
सर उसके लिए ऊपर के 4 लाइन और पढ़ लें सर. उन्होंने क्या कहा?
पढ़ ली, अब तो पूरा एक लाइन पढ़ ली, तभी तो आपको पूरा पढ़वाया
सर. And I am not. If my lord, off the record, if I may just submit, my lord, if for ignoring for 2 minutes, my lord, that he might have signed on dotted lines, my lord, the order of the reference made by the registering authority and collector, my lord, can the collector, my lord, divorce and my lord, ignoring all these statutory provisions, my lord, only simply can he just affirm the reference order made, my lord. एक बार कलेक्टर का ऑर्डर देख लें सर.
ठीक है ना, तो
मैं सर अगर ये मान ले कि इन्होंने गलत ऑर्डर किया है,
मैं तो
कलेक्टर
क्या
ने
बोल
क्या
रहा हूँ,
किया?
उसमें क्या चाहिए, उसमें होना क्या चाहिए? रिमांड होगा
मतलब अब 2002
भाई. अरे वो इम्पोर्टेंट नहीं है 2002. इम्पोर्टेंट फिस्कल लॉ के बारे में क्या प्रोविजन है, वोडाफोन में क्या डिसाइड किया है.
मतलब
इट हैज टू बी स्ट्रिक्टली इंटरप्रेटेड.
यस
ठीक है ना, वहां पर कोई इफ एंड बट नहीं चलता है फिस्कल लॉ में. वोडाफोन में यही जजमेंट आया है
सर, आई बोड ऑन.
ठीक है, तो ये भी फिस्कल लॉ का इंटरप्रिटेशन
Yes,
है.
my lord. And it is for generating revenue, my lord. My lord, if it has to be construed strictly, my lord, then the 75 rules have to be construed strictly, which the collector has absolutely ignored.
ठीक है, इसको लगाइएगा कागज.
My lord, my respectful submission, my lord, only the board of revenue has not signed, my lord, on dotted lines, my lord. In fact, the conduct of collector is also has to be seen.
ठीक. चलिए.
Here number 30.
मतलब जस्ट वन लास्ट मिनट, हमने तो 2 एविडेंस दिए थे, कलेक्टर ने तो कुछ भी नहीं देखा है सर.
हाँ ठीक.
At least, my lord, we had submitted two documents on evidence.
Yes, yes.
Collector has not even referred to them, my lord.
Yes.
And he has not taken pains to even get it valued on his own.
Yes. कागज लगा देना, वो नोट बहुत इम्पोर्टेंट है. ये सब किताबें मंगवा के बस्ता इकट्ठा भी.
Serial number 30. Shri Rahul Rawat.
कोई नहीं है क्या? आइए दिवाकर जी, फिर आपका बोर्ड पे ही लिखा देते हैं अभी. उतना जो है बच्चे बुला लीजिए, सरकारी वकील साहब बुलाइए अभी लिखा देते हैं. दीजिए किताबें रखिएगा यहाँ पर. दिस विल बी द लास्ट केस. WP 5289 of 2004. This writ petition is filed by the state of Madhya Pradesh and the collector of stamp Jabalpur, being aggrieved of the order dated 20th June 2003 passed by the learned Board of Revenue in appeal bearing number 880-4/2003, whereby learned Board of Revenue has set aside the orders of the collector of stamp Jabalpur dated
28/3/2002.
28/3/2002. 2002. Full stop. Brief facts
And,
leading to the present
and order of the commissioner also.
writ petition are that appellant respondent herein had क्या रिस्पॉन्डेंट नंबर 1 ने रिस्पॉन्डेंट नंबर 2 को बेचा था ये?
सर रिस्पोंडेंट नंबर 2 तो हमने जिससे खरीदा है वो.
हाँ वही तो रिस्पॉन्डेंट. आप रिस्पॉन्डेंट नंबर 2 के लिए है ना?
1 के लिए सर.
1 के लिए सत्य प्रकाश बिल्डर्स के लिए. और 2 क्या है? 2 से खरीदा है
2
आपने?
से हमने खरीदा है.
हाँ, देखिएगा क्या लिखा. That petitioner number 1 purchased a commercial building from respondent number 2, full stop. At the time of registration, certain stamp duty was paid, which was found to be deficit, and therefore collector of stamps Jabalpur, valuing the property at rupees 4 crores 53 lakhs 13,000, found deficiency of stamp duty to the extent of, आप लोग दोनों बैठ जाइए आराम से, 12 lakhs 59,845, full stop. That amount was demanded and it was admittedly deposited by the respondent number 1, full stop. After depositing the amount, respondent number 1 preferred an appeal against the decision of the collector of stamps dated 28/3/2002 before the Revenue Commissioner, Jabalpur Division, Jabalpur. Full stop. Next para. This appeal came to be registered as case number 18/B-105/2001-2002 and was decided on 26/4/2003. Full stop. Commissioner, Jabalpur Division, Jabalpur upheld the orders of the collector of stamps and recorded a categorical finding that when valuation was made, then respondent number 1 herein had deposited the deficit court fee on 30th March 2002 and thereafter, as an afterthought, raised a plea of depositing said deficit stamp duty under protest. Full stop. It also recorded a finding that though appellant respondent number 1 had taken a plea that road was not being used by the owner of the property and therefore appropriate rebate should have been given for non-use of the road was not made out, as non-use of the road will not have impact on the valuation of the property, and held that since road is constructed on both the sides of the hotel on which there exists entrances to the hotel, then merely non-use of a particular gate will not cause any undervaluation of the any reduction in the valuation of the property. Full stop. Next para. Being aggrieved of the said order of the commissioner, appeal was filed. Second appeal was filed by the respondent number 1 herein before the Learned Board of Revenue, Gwalior. Full stop. This appeal was registered as case number 880-4 FOUR/2003 and that came to be decided on 20th June 2003, whereby Learned Board of Revenue had set aside the demand raised by the collector of stamps towards the deficit stamp duty amounting to rupees 12,59,845 and directed for refund of the same. Next para. Shri G.P. Singh, Learned Government Advocate for State, submits that the action of the action of the Board of Revenue is cryptic. It could not have directed for refund of the amount of stamp duty deposited by the respondent number 1, purchaser of the property, without arriving at a conclusion that the findings recorded by the collector of stamps are perverse or there is violation of any rules and regulations. Full stop. It is reading from the judge order of the Board of Revenue. It is pointed out that there is no iota of discussion in regard to violation of any of the principles of natural justice or violation of any provisions contained in the Stamps Act or the rules framed thereunder. Thus, the impugned order of the Board of Revenue deserves to be set aside and be set aside. Next para. Shri Rahul Divakar, appearing for the respondent number 1, has submits that firstly, circle rate cannot be the only basis to determine the market value. Full stop. Other factors like the age of building, comma, the construction quality, comma, the location, etc., has to be seen as well. Full stop. He has placed reliance on the judgment of Madhya Pradesh High Court in 2004 दीजिएगा। ये in state of MP and another versus PB Menon and others 2004 within bracket 1 MPLJ 285 full stop. Reading this judgment, it is submitted that in para 3 of this judgment, ordinate bench of this court 3 नहीं है इसका 11 है शायद. In para 11 of this judgment 3 हटा दीजिएगा. Ordinate bench of this court has considered scope of section 47A and has held that Apex Court and various high courts have held that basic valuation register cannot be the basis to determine the market value. Full stop. Thus, the author of the judgment recorded a finding that in his opinion, the orders passed by the collector of stamps as well as commissioner were wholly unrealistic and bad in law, and Board of Revenue passed the order making the valuation which cannot be said to be impermissible or without jurisdiction. Full stop. Thus, it is submitted that order passed by the collector of stamps without taking into consideration surrounding circumstances is bad in law and cannot be given a seal of approval. Full stop. Reliance is next para. Reliance is also placed on decision of 2004 का 2 दीजिए SCC. चार का 2 SCC का है, इसमें तो नहीं है 4 का 2 SCC नहीं है भाई. उसके साथ नीचे क्या रखिए स्टैम्प एक्ट के 4 का 2 99 का 5 96 का है आपके पास दे दीजिए
99 का 5 बाबू साहब
नहीं 2004 का 2 पहले
4 का 2
पेज नंबर 9
पेज नंबर 4 का 2 पेज निकाल
हाँ मुझे दे दीजिए मैं निकाल लूंगा
99 का 5 99 का 5
has placed reliance on Supreme Court judgment in R. Sai Bharti versus J. Jayalalitha and others 2004 का 2 SCC 9 referring to paragraph 22, 23 and 24. It is submitted that guideline value has relevance only in the context of section 47-A of the Indian Stamp Act, which provides for dealing with instruments of conveyance which are undervalued. Full stop. The guideline value is a rate fixed by authorities under the Stamp Act for purposes of determining the true market value of the property disclosed in an instrument requiring payment of stamp duty. Full stop. Thus, the guideline value fixed is not final, but only a prima facie rate prevailing in an area. Full stop. It is open to the registering authority as well as the person seeking registration to prove the actual market value of the property. Full stop. The authorities cannot regard the guideline valuation as the last word on the subject of market value. Full stop. This position is made clear in the explanation to Rule 3 of the Tamil Nadu Stamp within bracket prevention of undervaluation of instruments bracket close Rules 1968. Next para. In para 24, in case of R. Sai Bharti, it is held that the scheme of the enactment and the rules contemplate that guideline value will only afford a prima facie basis to ascertain the true or correct market value. Full stop. Undue emphasis on the guideline value without reference to the setting in which it is to be viewed will obscure the issue for consideration. Full stop. It is clear, comma, therefore, comma, that guideline value is not sacrosanct as urged on behalf of the appellants, comma, but only a factor to be taken note of, comma, if at all available in respect of an area in which the property transferred lies, full stop. In any event, comma, therefore, comma, if for the purpose of the Stamp Act, guideline value alone is not a factor to determine the value of property, comma, its worth will not be any higher in the context of assessing the true market value of properties in question to ascertain whether the transaction has resulted in any offense so as to give a pecuniary advantage to one party or the other. Full stop. Reliance is also placed on the decision of Supreme Court in Ramesh Chand Bansal and others versus District Magistrate oblique Collector Ghaziabad. वो किताब रहने दीजिए अभी, रहने दीजिए, उसमें मैंने कुछ निशान लगाया है, आप बीच में से ऐसा मत करिए उसको। 2004 का 2 SCC रखे रहने दीजिए यहीं पर। क्या लिखा? चलिए इनको चेंज कर लिया, आ जाइए, आप आ जाइए। Ramesh Chand Bansal and others versus District Magistrate oblique Collector Ghaziabad and others, 1999, 5 SCC 62, wherein placing reliance on para 5, it is submitted that Honorable Supreme Court has held that the object of the Indian Stamp Act is to collect proper stamp duty on an instrument or conveyance on which such duty is payable. Full stop. This is to protect the state revenue. Full stop. It is a matter of common knowledge that in order to escape such duty by unfair practice, comma, many a time undervaluation of a property or lower consideration is mentioned in a sale deed. Full stop. The imposition of stamp duty on the sale deed is on the actual market value of such property and not the value described in the instrument. Thus, an obligation is cast on the authority to properly ascertain its true value, for which he is not bound by the apparent tenor of the instrument. Full stop. He has to truly decide the real nature of the transaction and value of such property. Full stop. For this, comma, the Act empowers an authority to charge stamp duty on the instrument presented before it for registration. Full stop. The market value of a property may vary from village to village, comma, from location to location, and even may differ from the sizes of area and other relevant factors. Full stop. This apart, there has to be some material before such authority as to what is the likely value of such property in that area. Full stop. In its absence, it would be very difficult for such registering authority to assess the valuation of such instrument. Full stop. It is to give such support to the registering authority that Rule 340-A is introduced. Full stop. Under this, the collector has to satisfy himself based on various factors mentioned therein before recording the circle rate, comma, which would at best be the prima facie rate of that area concerned. Full stop. This is merely a guideline which helps the registering authority to assess the true valuation of a transaction in an instrument. This gives him material to test prima facie whether the description of valuation in an instrument is proper or not. Full stop. Similarly, reliance is placed on the decision of Supreme Court in Mohanlal within bracket diseased bracket close through his LRs Kachru and others versus Mirza Abdul Ghaffar and another within bracket 1996 bracket close 1 SCC 6 नहीं ये गलत हो गया 609 आपने फ्लैग गलत हो गया पार्टी का नाम in case of state of Punjab and others versus Mohabir Singh and others 1996 1 SCC 609 wherein referring to para 5 and 6 it is pointed out that the value of the property varies from place to place or even from locality to locality in the same place. Full stop. No absolute higher or minimum value can be predetermined. Full stop. It would depend on prevailing prices in the locality in which the land covered by the instrument is situated. It will be only on objective satisfaction that the authority has to reach a reasonable belief that the instrument relating to the transfer of property has not been truly set forth or valued or consideration mentioned when it is presented for registration. Full stop. The ultimate decision would be with the collector subject to the decision on an appeal before the district court as provided under subsection 4 of section 47A. Full stop. It is further held that guidelines provided by the state would inhibit the registering authority to exercise his quasi-judicial satisfaction of the true value of the property or consideration reflected in the instrument presented before him for registration. Full stop. The guidelines would only serve as prima facie material available before the registering authority to alert him regarding the value. Full stop. Reliance is also placed on the judgment of Supreme Court in Prakashvati bracket में Srimati versus Chief Controlling Revenue Authority, Board of Revenue, UP at Allahabad and others, 1996 4 SCC 657, to point out that objective satisfaction while calculating the market value, the age of building is also to be considered. Full stop. It is further submitted that for making a reference under section 47A, 47 within bracket A of the Stamp Act, the sub-registrar has to arrive to a conclusion that the party had the intention to evade stamp duty and unless that conclusion is drawn, no reference could have been made in routine manner. Full stop. Reliance is placed on the judgment of Supreme Court in V.N. Devados versus Chief Revenue Control Officer cum Inspector and others, 2009 का 7 SCC 438, wherein in para 13 it is held that subsections within bracket 1 bracket close and within bracket 3 bracket close of section 47 dash capital A clearly reveal the intention of the legislature that there must be a reason to believe that the market value of the property, which is the subject matter of the conveyance, has not been truly set out in the instrument. Full stop. It is not a routine procedure to be followed in respect of each and every document of conveyance presented for registration without any evidence to show lack of bona fides of the parties to the document by attempting fraudulently to undervalue the subject of conveyance with a view to evade payment of proper stamp duty and thereby cause loss to the revenue. Full stop. Therefore, comma, the basis for exercise of power under section 47 dash capital A of the Act is willful undervaluation of the subject of transfer with fraudulent intention to evade payment of proper stamp duty. Full stop. Similarly, reliance is also placed on the decision of Supreme Court in Residents Welfare Association, Noida versus State of Uttar Pradesh and others, 2009 का 14 SCC 716, wherein relying on paragraphs 19, 52 and 53, it is pointed out that क्या लिखा? That for the authorities for the purpose of invoking section 47 dash capital A, it is not sufficient to note that the consideration amount stated in the instrument of sale is less than the prevailing market value, but they must be satisfied that there is an attempt of undervaluation. Full stop. In this context, it is held that date on which agreement was executed is material date and not the date on which instrument was actually registered, in as much as if for the intervening delay buyer or seller cannot be said to be responsible and the intervening delay is on account of third party, like in that case it was the Noida authority, then merely increase in the valuation of the property will not put the seller or buyer to any disadvantage. Full stop. It is also submitted that Gwalior bench of this High Court in Messrs. Ria Malls and Hotels India Private Limited versus State of MP and others in WP 12650 oblique 2019 decided on 24/4/2022 has held that circle rates cannot be the basis, and in fact the market value has to be determined as per the statutory rules of 1975. Next para. Reliance is also placed on the judgment of full bench of this High Court in Bala Prasad and another versus State of MP and others 1997 within bracket 2 bracket close MPLJ 636 to point out that full bench of this court has held that market value is to be determined in consonance with other factors. Full stop. In para 10, it is held as under. Para 10 and 11, it is held as under. ये कोट कर दीजिएगा इसके para 10 and 11. Thus, reading it, these judgments, it is pointed out that there could not have been a reference by the referring authority without recording a finding of deliberate attempt to undervalue the instrument, and market value can be determined only in terms of the rules of 1975, namely prevention of Madhya Pradesh MP prevention of undervaluation of instruments rules 1975. It is pointed out that since provisions contained in rule 4 and 5 were not followed, therefore the impugned orders passed by the collector of stamps and the commissioner are perverse, and they have been rightly set aside by the Board of Revenue. Next paragraph. After hearing learned counsel for the parties and going through the record, certain facts needs to be re-emphasized. Full stop. Firstly, instrument was admittedly presented during the financial year 2001-2002. Next paragraph. Guidelines of 2001-2002 were applicable. Full stop. Next paragraph. Learned counsel for respondent number 1 is not disputing the valuation in regard to the land. Full stop. Whole dispute is raised in regard to the valuation of the building. Full stop. It is submitted that chartered valuer. कहाँ गया वो कागज? नहीं आपने दिया था. कागज कहाँ चला गया? जी उसी कागज कहाँ रखे? ये रखा है. That one chartered valuer, Marwa and Associates, surveyors / loss assessors and approved valuers had valued the building measuring 31,200 square feet, where only pointing out that construction had started in 1963 and was completed in 1970, holding the life of the building to be 45 years. At rupees 69 lakhs, $10,925, out of which valuation of other facilities such as lifts, compound wall, septic tank, boring, etc. was to the tune of rupees 4 lakhs, and other parts of the building, different floors of the building were valued at rupees 360 for the ground, 360 per square feet for the ground floor, 300, 260, 270, 300 respectively for the first, second, third and fourth floor. Full stop. It is submitted that this valuation should have been taken into consideration by the collector of stamps. Next, it is also pointed out that building was insured and a cover was obtained from the National Insurance Company to get the building insured, namely Messrs. Ashoka Hotel, and this policy was valid from 4/12/2001 up till midnight of 3/12/2002, and since the gross total of sum insured was 65 lakhs, therefore collector of stamps should have at best taken this valuation of insurance to be the valuation of the building and could not have exceeded the valuation. Full stop. A chart is also produced to demonstrate that building was not in a commercial area and therefore commercial rates have been arbitrarily applied. Next para. After hearing learned counsel for the parties and going through the record, certain facts needs to be clarified. Firstly, as held by a coordinate bench of this court in case of PB Menon, High Court cannot substitute the valuation until and unless it is shown to be wholly perverse, unrealistic. Full stop. The finding of fact recorded by the Board of Revenue is proper. Full stop. No interference is required in the order passed by the Board of Revenue. Full stop. In the present case, there are no findings of fact recorded by the Board of Revenue. They have not referred to the method of valuation or how the valuation supplied by the respondent number 1, who was appellant before the Board of Revenue, as was carried out by the registered surveyor / loss assessor and approved valuers, was just and appropriate, and how the valuation of sum assured can by implication be incorporated to take into consideration valuation of a building has not been dealt with by the Board of Revenue. Therefore, the valuation, which is a matter of fact in the light of the judgment of coordinate bench of this High Court, on which reliance is placed by Shri Rahul Divakar in case of PB Menon, can only be the valuation made by the authorities. Full stop. High Court cannot substitute the valuation. Full stop. Thus, the requirement for the respondent number 1 is to show that the valuation made by the authorities is perverse and unrealistic. Full stop. Admittedly, as boils down from the judgments referred to above, respondent number 1 was authorized to produce copies of the sale deeds of the preceding or succeeding years of the same locality to point out that how the valuation made is perverse and deserves to be set aside. Full stop. No such attempt has been made by the respondent number 1. full stop. It is an admitted position that no such sale deeds were produced by the respondent number 1 while adducing evidence before the collector of stamps. Therefore, admittedly, respondent number 1 failed to adduce evidence to show that what was the valuation of similarly situated properties in the same locality or close by localities, so to dispute the valuation of building made by the collector of stamps. Next paragraph. Even otherwise, when Rule 5 of the Rules of 1975 is taken into consideration, then it provides for the principles for determination of market value. Full stop. These principles, which have been enumerated under 4 subheads, namely A, bracket mega small a, bracket close, comma, within bracket small b, comma, small c, and small d, reveals that in the case of buildings, comma, it is type and structure, comma, locality in which constructed, comma, plinth area, comma, year of construction, comma, kind of material used, semicolon, rate of description, semicolon, fluctuation in rates, semicolon, and any other features that have a bearing on the value besides local rates, comma, municipal or other taxes to which such building may be subject, and valuation of building with reference to taxation records of local authority concerned, semicolon, the purpose for which the building is used, इसको highlight कर दीजिएगा, bold कर दीजिएगा, the purpose for which the building is being used and the income, comma, if any, comma, by way of rent per annum secured on the building, semicolon, and any special feature of the case represented by the parties are to be considered. Full stop. Thus, it was open to the respondent number 1 to have produced local rates, comma, rates of municipal or other taxes. Full stop. Next paragraph. Learned Board of Revenue has said, has held in its order, has observed in its order that collector of stamps treated the building to be situated in a commercial area. Full stop. This finding of the Board of Revenue is perverse on face of record. Full stop. Firstly, as per the classification produced by Shri Rahul Divakar, comma, classification is in regard to use and not in regard to locality. Full stop. Classification has been made for residential and commercial purposes. Thus, it is not the locality which is material, but the use of the building which is paramateria. Full stop. Thus, once it is admitted position that the building in question was used for commercial purpose, then merely saying that it was only used to let out the rooms and there was no provision to run a restaurant or to run a sweet shop, therefore it will not be treated as a commercial establishment, is against the classification made by the authorities in exercise of their power under the provisions of the Madhya Pradesh Preparation and Revision of Market Value Guidelines 2000. Full stop. These rules are statutory. They have been framed in exercise of the powers conferred by Section 75, read with Section 47 capital A of the Indian Stamp Act 1899. Full stop. Thus, unless it is shown that these rules have been framed without authority or are not statutory in nature or that the purpose of framing these rules is at crossroads with the purpose of determination of the market value, then no advantage can be derived by the respondent number 1. In fact, in almost all the cases cited by learned counsel for respondent number 1, it is held that the guidelines are indicative of the tentative market value, full stop, but they are not sacrosanct, full stop. Other relevant factors should be taken into consideration, but consider those relevant factors are required to be produced by the person who is claiming rebate on stamp duty or any concession from payment of adequate stamp duty, full stop. Thus, in absence of any evidence being led by the respondent number 1 before the collector of stamps, he is now, which is an admitted position, that he had not produced any copy of sale deeds of the preceding or succeeding year before the collector of stamps.
I may just submit, my lord. We have not claimed any rebate, my lord, or concession, my lord.
Rebate and concession word हटा देना.
In fact, my lord, we did
Challenging
not
the
approve the
valuation
collector, my lord.
for challenging, वो आ जाए, correct हो जाएगा. Challenging the valuation of the property. No evidence was produced except for the report of the valuer, full stop. Valuer has not mentioned as to which process was adopted by him and which method was followed by him to value the property and how he came to take into consideration various values which are mentioned in his report, full stop. In fact, the report itself appears to be cryptic at the first glance, where after taking valuation of the ground floor at rupees 360 per square feet, valuation was reduced to 300 rupees for the first floor, then 260 for the second floor, and then arbitrarily increased for the third floor to rupees 270, and then again increased to 300 rupees for the fourth floor, full stop. The valuer was required to substantiate from any manual of the building congress or civil engineering that on what basis these rates have been arrived at and how they, and was required to justify them. There is no justification, and therefore the report of the valuer being not a sacrosanct report and not supported by any cogent evidence to substantiate the same, it cannot be said that collector of stamps committed any error in overlooking these reports. Next paragraph. Coming to the next argument, that unless and until it is pointed out that there was an attempt to undervalue the property, comma, with a view to evade stamp duty, no reference could have been made under section 47A, full stop. The fact of the matter is that there is a huge difference in the valuation and differential stamp duty to the tune of rupees 12,59,845, full stop. Principles of mens rea are not applicable in civil law, full stop. Collector of stamps was not required to point out that there was a guilty mind and therefore the undervaluation was required to be substantiated is not made out. In fact, once it has come on record that valuation was made by following the market guidelines as prescribed under the rules of 2000, then the huge difference in the valuation, which is apparent, the valuation of the land comes to the tune of rupees. where the valuation of the land comes to rupees 3 crores 30 lakhs 20,100, and that of the building comes out to rupees 1 crores 22 lakhs 92,800 against a valuation of 69 lakhs, comma, it is apparent on face of record that there was undervaluation of the instrument which was required to be charged properly, and therefore the authorities passed the order when he made a reference, and then collector of stamps passed the impugned order, full stop. There is no error in the order passed by the collector of stamps and the revenue commissioner in appeal, full stop. Next para. In fact, the Board of Revenue got swayed by certain facts, and in the stream of various judgments cited by it in its reference order, it did not advert to the correct facts. It committed several mistakes, full stop. Without there being any material on record, it held that appellant had deposited the differential stamp duty under protest, full stop. No such material is available on record. Next. Similarly, it held that the sub-registrar treated the property to be in a commercial area, whereas no such list was produced from the Municipal Corporation Jabalpur to show that the property in question was situated on a commercial road, full stop. It held that Subhadra Kumari Chauhan Marg is not a commercial street and it has not been declared as commercial street, therefore found fault with the valuation, full stop. It failed to deal with the aspect and differentiate that property being situated in a commercial area and property being put to a commercial use are two different aspects, and the valuation in the present case was made treating the property to be put to a commercial use and not being situated in a commercial area, and this fine distinction could not be drawn by the learned Board of Revenue, prejudicing its order on merits. Next para. It has further held that sub-registrar failed to examine sale deeds, registered sale deeds of the area for last 5 years, full stop. It has not pointed out as to under which provision of the rules of 1975 collector of stamps was suo motu required to examine sale deeds of last 5 years, full stop. It has not adverted to the fact that in fact onus was on the assessee to have produced the sale deeds to point out that the assessment made is inappropriate and the last 5 years sale deeds of the same locality or of the same area point out that market guidelines are either arbitrary or cryptic, full stop. Admittedly, no such effort was made by the assessee. Therefore, decision rendered in case of Bala Prasad versus State of Madhya Pradesh, AIR 1997 MP 218 is not applicable to the facts and circumstances of the case. Next para. It is further observed that collector of stamps neither carried out spot inspection nor paid attention to the documents furnished by the appellant, full stop. It has overlooked the technical report furnished by the appellant, that is the assessee, and has arbitrarily agreed with the report of the sub-registrar. It further went to observe that collector of stamps is not an engineer or is not a technical person, is not engineer, is not a technical person, and directed the state government to appoint technical officers for judicious decision in the matter of valuation of properties. Full stop. This observation is obiter. Full stop. There is no material on record under the rules of 1975 or under the scheme of the Stamp Act authorizing the member board of revenue, learned member board of revenue to direct the state government to appoint technical officers for valuation of properties. Full stop. There is no such intent reflected from the act or the rules that valuation can only be made by technical officers and not by the collector of a stamp. Therefore, the whole order being cryptic, based on surmises and conjectures, and not dealing with any of the legal issues which have been raised by Sri Rahul Divakar now, that is non-compliance of section 47A, violation of the rules of rule 4 and 5 of 1975 being not dealt with by the commissioner and having been not raised by the respondent assessee before the competent authority, that is the collector of stamps, and the commissioner, so also board of revenue, could not have been raised now for the first time. But note of the fact that वो 2004 का दीजिए जजमेंट, और आपकी किताब थी ना, भाई दीजिए। नहीं, पेज नंबर क्या था? 2004 का। अरे भाई MPLJ नहीं, SCC। क्या लिखा? That in case of R. Sai Bharti, Honorable Supreme Court in para 22 has held that the guideline value fixed is not final, but only a prima facie rate prevailing in an area. Full stop. It is open to the registering authority as well as the persons seeking registration to prove the actual market value of the property, and that can be proved by resorting to the circumstances which are mentioned in Rule 5. Full stop. Since the respondent number 1 failed to prove that the market value of the property is below the guideline value by producing cogent evidence in the form of sale deeds of the area for the current for the said financial year or the immediate preceding financial year or the succeeding financial year, the order of the Board of Revenue cannot be given a seal of approval, it being cryptic and having failed to take into consideration various legal provisions and having been passed without there being any basis, and in the light of the judgment of Madhya Pradesh High Court in PB Menon, where it is held that court cannot substitute its opinion for the valuation which is arrived meticulously, since board has not applied itself to discard the valuation made by the collector of stamps, impugned order passed by the Board of Revenue cannot be given seal of approval. It deserves to be quashed and is hereby quashed. Petition is allowed and disposed of.
May I make a
हाँ बताइए सर।
सर एक मैटर था 4:35 के लिए आपने रखा था मीडिएशन।
हाँ वो चेम्बर में आ जाइए, तुरंत आ जाइए, मेरे को फिर एक मीटिंग में भी जाना है। हाँ दैट आई विल टेक।
Lordship, item number 74, a request matter tha, Lordship. Similar parity is there, Lordship, by this round.
Yes, matter serial number 74.
आप लोगों को चेम्बर में बैठा हूँ। क्या सिमिलर मैटर है? क्या है भाई?
There are, Lordship, 3 accused there. So, my IA remain during the 25th May. वो छूट गया था सर IA. Yes, धनीराम.
ठीक है, इसको मैं देख के कर दूंगा।
Lordship, Obile.
Lordship, may I make one single clear? Lordship, I have mentioned the item number 92. It was in request, Lordship. On the last date, on 12th June 2023, Lordship has directed to verify from the state that why the police has given a notice of 160 without registering the FIR.
इसको मंडे को रख ले।
मंडे सर मैं बाहर हूँ सर। ट्यूसडे
रख दीजिए इसको। 92 को ट्यूसडे रख दीजिए।
Ever so blessed, Lordship.
74 में there is direct allegation of
इसीलिए मैं इसको देखे, इसको सुनिए, 74 को भी सुनिए। एक मिनट रुक जाइए, इसको मंडे को रख लीजिए, मंडे को टॉप ऑफ द लिस्ट कर लीजिए।
सिर्फ आइए उस दिन मैंने बहस
मंडे को कंसीडर करेंगे, सुन के अभी जल्दी में नहीं हो पाएगा, ठीक है ना? चलिए
सर वो ट्यूसडे को भी टॉप ऑफ द लिस्ट
बोल दिया भैया।
अब
डायरेक्ट तो आ रहा सूरज पटेल का, हमारा नहीं है।
चारों का नाम है
नहीं वो तो है, लेकिन उसमें जो है आपका डाइडेक्लेशन 2 बंदे बात लिखा है ना मानने पहले, वो चीज सूरज पटेल के लिए डायरेक्ट है, हमारे में नहीं है। गलत नहीं, नाम तो है नहीं, बाकी का 3 लोगों का ग्रांट किया ना साहब, आपको नहीं मालूम है?
एक की लगी है।
नहीं 2 की ग्रांट हो गई तालुका साहब। ये रहा
ऑर्डर दे दे, एक कॉपी में
नहीं वो आप
मत दीजिए, मंडे को जिसके पास नहीं है।
हाँ ये जो है
सर आवाज आ रही मेरी?
मुझे सुनाई दे रहा है, आपको मेरी आवाज आ रही है?
जी जी आ रही है।
थैंक यू।
सर आ रहे हैं, अभी ज्वाइन करते हैं।
ठीक है, थैंक यू।
ठीक है, आप वेट करिए थोड़ा सा।
हाँ जी श्योर।
जी सर रुकिएगा सर।
कौन सा है क्या ये काटा का ठीक होना चाहिए
सर 2 मिनट वेट करिए, साहब आ रहे हैं।
बिल्कुल मैं वेट कर रहा हूँ, बिल्कुल।
बहुत बड़ी रस्सी थी बताओ और क्या